Item for pronouncement of judgment. Item 1, WPC 4362 of 2024.
Mission allowed.
I am deep.
May I have a look?
Yes.
I have some urgent matter to move. What it can permit today to move. Matter, my lord, basically relates to, my lord, the prejudice evidence. I was to cross-examine, my lord. I could not because my counsel was ill, my lord. The trial court has closed the, my lord, the evidence and, my lord, picked for, my lord, DWS.
When do you want?
My lord, if possible today or not, otherwise tomorrow, my lord.
Today is hearing day. We have some old matters. Tomorrow?
Tomorrow.
Day after tomorrow. No,
Tomorrow, not
okay.
day after tomorrow.
Tomorrow.
Tomorrow, my lord. Day after tomorrow, I'll not
Okay,
be there.
okay.
Tomorrow.
Yes.
Please, your lordship. This civil revision petition, my lord, may it be listed on Friday for admission, my lord.
Friday.
Friday, my lord.
Okay.
Friday 4th.
My lord. My
Yes.
lord. And
On
one
7th, Monday. 4th, we have
my lord,
few
my
more
lord.
cases.
Friday, if possible, my lord, in the trial court, my lord, day
Okay.
6 and 7.
Okay.
And one testamentary appeal, my lord, this may come up on Monday, my lord,
Okay.
for admission. Much obliged.
May I
Yes.
please, your lordship, I beg to mention item number 17 and 18. We have also taken consent from the other side.
When do you want?
Kindly list the matter to some another day, any day.
You are appearing for?
I'm appearing on behalf of respondent number 6, item number 18.
Is your good name, please?
You, Roy, appearing on behalf of Mrs. S. Roy.
Ms. Roy, learned counsel. Appearing on behalf of Mr. S. Roy.
Mrs.
S. Roy, learned counsel for the respondent, conducting counsel for the respondent number 2. With consent from the
Respondent
from the
number
other
6.
side.
Respondent number, yes, your lordship.
With consent from the other side, press for listing the matter. After?
Any day. Any-
After?
After Bihu,
After
the
Bihu vacation.
Fair allowed. Yes.
much obliged.
May it please, your lordship. Lordship, I beg to mention CRP IO for orders, your lordship, on
When?
Friday. Friday.
Friday. Okay.
Deeply.
May I please, lordship, I beg to mention item number 7 of the total.
7.
Yes, your lordship. The matter possible for the day, your lordship, only. Any day.
You are for petitioner or respondent?
Petitioner, your lordship.
Mr. Your good name?
S. Roy, your lordship.
S.
S. Roy.
Mr. S. Roy, learned counsel for the petitioner. With consent from the other side, press for you inform the other side.
Council, government is there.
Okay. Press for
7.
adjournment of the matter for the day. Fair allowed.
Your lordship, may pick any date, your lordship. This is eviction matter, your lordship, actually.
On 25th April. After Bihu. After
Your
Bihu.
lordship, actually eviction matter, then maybe
When do you want?
this week, any date, your lordship.
On 10th April.
May I please, your
Okay,
lordship.
this week.
This week, lordship.
Friday.
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 Yes.
May I please, your lordship.
May I please, your lordship?
Next Friday. Your matter will be taken up on Friday.
Yes, your lordship. Possible.
Lord, I beg to mention item number 10.
10.
10. Kindly, matter may come after 4 weeks. Time for the appellant. I have taken consent from the opposite.
Mr. Your good name?
E. Roy.
T. Roy, learned counsel for the appellant.
In this case, my lord, I am for the respondent.
Acha.
It's a very old pending case.
Actually, due to shifting
And
of
there
chamber, my
is a
record,
concurrent pending.
due to shifting of chamber, my record is misplaced. It is unable to submit. It is a time.
My lord, a date may be fixed after Bihu, my lord, the 6th of May.
6th of May. Okay. With consent from the other side, press for listing the matter on 6th of May. Fair allowed.
Majol.
May I please, your lordship? Your
Yes.
lordship, I beg to mention item number 12 and 13, your lordship. Kindly the matter be adjourned for the day, your lordship, and be fixed on next Tuesday, your lordship.
Mr. Your good name?
S. Paul, your lordship.
S. Paul, learned counsel for the
Appellant, your lordship.
appellant. With consent from the other side, press for. Any objection? No. With consent from the other side, press for listing the matter. When?
Next Tuesday, your lordship.
After Bihu, lordship. बहुत केस हो जाबो लड़के बहुत ठीक है
8. Your matter may not rest on that day.
after
After
Bihu
vacation.
24th Thursday,
Thursday, 24th.
24th.
Okay,
Okay, your lordship.
May I please, your lordship? Lordship, for listing of civil CRP, lordship, on Friday, lordship. It's an urgent matter, lordship.
okay, right. Okay,
May I please your lordship? Lordship, I beg to mention item number 15 for adjournment. Lordship.
item number?
15. Engaged counsel, Mr. Y.S. Mandan unable to make hearing on today for some personal difficulties.
You inform the other side.
Yes, Lord.
Your name, please?
R. Gogoi.
Ms. R. Gogoi, learned counsel, appearing on
Lordship.
behalf of Mr. Y.S. Mandan, learned counsel for the appellant. With consent from other side, press for listing the matter. When?
8 maybe 8, Lordship.
Next,
Next
8,
8.
Orders,
after vacation.
hearing after vacation. On 24th,
24th.
24th April.
My pleasure, Lordship.
Yes.
Back to for listing on IA, Lordship, for early hearing, Lordship. We
When?
filed in on 27 February, Lordship.
When do you
come,
want?
on Friday, Lordship.
Friday?
Friday, Lordship. Much obliged, Lordship.
Top of the list items, item 1, 2 and 3.
May I please?
Hmm.
Also, petitioners were
Wait,
stipendiary teacher,
wait. Volume. Yes,
petitioners were stipendiary teachers of Nazira subdivision appointed in the year 1995. Annexure 21 is the appointment order. Page 21. Annexure 1. May I read?
yes.
Subject to the discharge without any notice and assigning a region thereof, Mohendranath Mohanto, village Mumok Imaniman, and posted at Rajapuri Primary School with the following terms and condition. Initially, CEs will get stipend of rupees 900 per month, and subsequently he will be deputed for undergoing teachers training for 1 year, subject to availability of seat. After successful completion of training, he shall be allowed to do regular pay after approval of the Director of Elementary Education, Assam. If he cannot succeed in the training, she will be allowed to appear second time as private candidate, for which no PADA will be paid. If she cannot come successfully in the second chance, service will be terminated with period of 1 month from the date of announcement of the examination result, for which no claim and appeal will be entertained.
Hmm.
That's the original appointment that I ordered at page 22.
Hmm.
Accordingly, petitioner has joined Annexure 1, page 23. And petitioner has completed the basic training, page 23. After deputation, petitioner has completed the basic training. This is to certify that Mohendra Mohanto has passed Assam Junior Basic Teachers Training Examination held in the month of December 2020 under Director of SCRT Assam Guwahati and placed in this simple division. So petitioner has completed the basic training after deputation.
Hmm.
Originally is at page 24.
Hmm.
Like this, second petitioner at appointment order at page 25. And
25 is?
27.
No, 25 is?
25 is Lordship, after giving the basic training, he was given the scale of pay. Lordship, in pursuance of Director of Education Assam Kahilipara Guwahati, Mohendranath Mohanto stipendary teacher Rajgopal under Deputy Inspector of School Nazira, who has been placed past Junior Basic Training Examination on Iman, as per Director, has been allowed to draw regular scale of pay. After completion of basic training, as per order of appointment, they have been given regular scale of pay.
Hmm.
List of date I have given.
Okay, okay.
Lordship, petitioner has been given regular scale of pay with effect from 3/1/2002.
Hmm.
That is Lordship will page 25,
Hmm.
3/1/2002. Second, similar Lordship page Annexure 2 is the same appointment order in case of another petitioner, Chittaranjan Borgohai. Petition number 2. All the petitioner has completed junior basic training. And Lordship, up to page
How many
56,
petitioners are here?
total 14 petition.
Total.
Total
40.
14, 1-4.
1 4.
56. Up to 93, Lordship, the documents regarding appointment and junior basic training, up to page 93, Lordship. Regarding regular scale of pay, all the petitioners have been enclosed.
So all the petitioners have completed their basic training.
Basic training, thereafter regular scale of pay has been granted as per initial offer of appointment.
Last page is page number
93.
yes.
Lordship, thereafter page 94. Regarding retention of the post, page 94, permanent retention of the post. From Deputy Inspector of Schools to the Director of Elementary Education Assam regarding submission of 610 of incumbency list for permanent retention of the post primary school teachers under Nazira subdivision. With reference to the above, I have the honor to submit herewith 610 of incumbency list for permanent retention of the post of primary school teachers under Nazira subdivision for favor your kind information and necessary action. This is by Deputy Inspector of Schools. And our name has been reflected at page 96. List is page 96.
So the petitioner number 1 is at serial number
604. Page 113. Mohendranath Mohanto 604. Lordship, got it. Page 113.
604. Yes.
Mohendranath Mohanto. Next, Lordship, 607 Amulya Dotto. 608 Raju Kaur. Chittaranjan Guhai at 562. Kamal Bailung, serial number 571. Ojit Kolita.
1 minute. Bailung is at page number serial number 571.
571.
Yes. Next.
Next, Lordship, will find Ojit Kolita, serial number 590. List commission.
Yes.
List of and we have stated everything in paragraph number.
No, rest of the petitioners.
All name has been included. We have stated in paragraph number 18.
No, you tell me the serial number of other candidates.
Lordship.
You have stated about 6 candidates.
Lordship.
Petitioner number 1 604.
Petitioner, again, I am repeating, Lordship. Petitioner number 1 at 604. Page 113.
Petitioner number 2.
Petitioner number 2.
Page number 112.
607.
Page 112. 607.
Petitioner number 2
5? 562. Petition number 2, 562. Serial number. Chittaranjan Borgohai.
112 page.
562, page 112.
Yes, got it.
Petitioner number 3
Petition number 3,
590 serial number.
590, serial number.
112.
113. Page number 112, page number 112. Petition number
4
4,
607 serial number.
serial number 607.
Got it.
571 petitioner number 5.
571.
Petitioner number 5.
Kamal Bailung.
Kamal Bailung. Page 112. 571.
Petition number
Next.
608. Petition number 608.
Robert. Kamal Bailung Lordship got it.
Got it.
Petition number 6
608.
608. Raju
Yes,
Kumar.
Raju Kumar.
Raju Kumar.
7443.
7
443.
443.
4.
443. Page number 108.
813.
443 Rontumoni Konikor.
Rontumoni Khonikor.
Okay.
8. Serial number 8.
Serial number 8
No, 133.
133.
Petition number 8.
Serial number.
Serial number.
Petition number 8.
Petition number 8 133. Page number 100. Lokeshwar Das.
Lokeshwar Das.
Petition number
Next.
9.
Petition number 9
605.
605.
Padmeswar Gogoi.
Yes. Number 10. 353.
Is
Petition
it
number
Padmeswar Gogoi? 605?
605 Padmeswar Gogoi.
Okay.
10. Petition number 10.
Petition number 10
353.
353. Mahendra Gogoi at page 106. Page 106, 353.
Yes.
Petition number 11.
Petition number 11
305. 305.
305. Page number 104. Mridu Pawan Goswami. 305.
Petition number 12.
Petition number 12
598.
598.
Page 113.
Pauline Chandra Borua. 598, no? Page
Bolin
113.
Chandra Barua.
Pauline Chandra Borua. 598.
Yes.
13. Petition number 13.
Petition number 13
374. Serial number.
374.
Serial number 106.
Page 106. 374. Bosonto Raskumari. 374.
Yes.
Petition number 14.
Pet-
565.
Petition number 14
565.
565.
1150. Page 11.
Sundarsan Prasad.
That's it.
Okay.
Now let's see page 114. It is a letter from the Director of Elementary Education to the regarding sanction of temporary retention of 2755 of post of primary school teachers hereby accorded for a period 139 to 28/10/2010. Scale of pay allowances as admissible under rules. The subdivision wise breakup of 2755 posts is stated here below. Nazira is serial number 18. Nazira is serial number 18. 610. Now let's see the posts are within 8153 posts originally created under OBBCSS scheme government and brought under non-plan height government later dated Iman retained list height number Iman. The expenditure will be debited Iman. Hereafter Lordship will find page 115 copy to Lordship got it. District Elementary School Officer for information and necessary action. He is requested to ensure that payment is made to the incumbents he genuinely appointed against high sanction post and retained up to 28/2/2009, and no payment is made to any illegal, irregular appointed teacher or any appointed in excess of the post already allotted to the district. Originally that page 116, I have already shown the origin of the said letter. This is a type copy.
Yes.
Now next lordship, next retention order, page 118. This is letter from the Deputy Inspector of School Nazira to the District Elementary Education Officer. With reference to the above, I have the honor to submit herewith the original OBB retention list under Nazira subdivision, which is in continuing running with effect from 98/2/2010 for February for kind information and necessary action. Next letter from Deputy Secretary Government of Assam, page 120. Yes. Page 120, Lordship. This is letter to from the Deputy Secretary Government of Assam to the Accountant General. I am directed to convey the sanction of Government of Assam of temporary retention of Iman number of post of LP school teacher for period 1/3/2013 to 28/2014 in the usual scale of pay and allowances admissible. Post were originally created by government Iman, subsequently brought under non-plan Iman dated retained list Iman, subdivision wise breakup of the post annexer 1, expenditure under the head of Iman. This has been issued as per power delegated under Rule 1 of Schedule 2 of provision of DEF Rule 1999 is attended. Originally that page 112 and Lordship list is page 123. And in the list, page 124. Same list, our name is reflected.
So this is a district wise.
District wise.
Okay.
Our name also is included in the list. May I point out the name also, Lordship, in the serial number? Lordship, Mohendra Dutt Mohanto at 454, page 131. Mohendra Dutt Mohanto, 454, serial number. Lordship, got it?
454.
454, page 131.
Yes.
454. Next, Lordship, Nirupama Sohoria, 459. 475, sorry, 475. Petition number 2. Sitaranjan Borgohai, 475. Petition number 3. 453.
Ojit Kolita.
Ojit Kolita.
Petition number 4452.
Petition number 4452. Petition number 502. Kamal Bailung.
No, 452.
452 is Kamal Bailung.
452 serial number.
Serial number 452.
No. Omiya Dotto.
Amulya Dotto. He is also petitioner.
Serial the petitioner number
452. Serial number
452. His
Petition number
petitioner number
4.
Okay.
Petition number 5502.
Kamal Bailung.
Kamal Bailung. Petition number 6. 507.
Number second, 461.
Petitioner number 7,
461.
461.
Rantomani Konikor.
Yes.
Yes.
Petition number 8,
Petition number 8,
484.
484.
Lokeshwar Das.
Lokeshwar Das.
Petition number 9,
Petition number 9,
serial number 6,
serial number
6,
6,
page 150.
page 124. Page 124.
Yes, serial number 6.
Serial number 6.
Petition number 10,
Petition number 10,
462,
462.
131.
Page 131.
Yes.
462.
Petition
Petition number 11,
51.
511. Same page. Ridhupavan Goswami.
Petition number 12,
Petition number 12,
487.
487.
13, 485.
Yes.
13 to 485.
13, 485.
Petition 51.
Petition number 14, 512.
Five one two.
Lordship, 512.
Sudarshan Prasad.
Lordship.
Yes.
Now, Lordship, petitioner not getting salary, petitioner has earlier approached this court. Page 134.
No, since when they have not received the salary?
Up to February 2016, they have got the salary as per High Court's order.
February 2016.
16.
As per this order.
Lordship, not subsequent order. We have to approach this third time now. We are approaching this court.
So, what was the payer in this petition?
In this petition,
WBC number 480.
page
No,
840
840.
2007. Page 134.
Yes.
Now, Lordship will find it is a division bench order. Now to the relevant portion, Lordship will find para 5. 138.
Yes.
Para 5, Lordship. We are shocked and surprised, say astonished to hear the argument and defense raised by the respondent. If the state government finds that there is an excessive appointment, then they should have taken the appropriate action immediately, not only against the teachers, but even against the person who had appointed the teachers in excess the cadre's rank, and should have also directed for prosecution, and should have at least issued certain direction in relation to the recovery of money. The question that there is an excess appointment of the teachers in the cadre is a simple lip service, but there is nothing beyond that. If in case of state government finds the excess number of teachers have been appointed, then it has to be thank itself because it wise and competent officers are violating the rules and laws. If government has no control over the officers and they will take action against those officers, then the state government should not take any action against the poor teachers who are still waiting payment of their salary to meet their ends. It is indisputable that since 1st December 2009 till date, salary of the teacher have been paid. If that be so, it will speak bad against the government, and the governments, it is always expected of the government that it will have to be a budgetary provision for making payment of the salary for the works. Though we may not sound little cut is saying that if the respondent number 2 to 7 in fact need their salary every month, how can they say that the petitioner would not need salary every month? Requirement of the food and clothing and shelters are the basic requirement for all concerned whatsoever. They are to maintain their family and standard of life. Respondent, in our opinion, cannot be allowed to say that because the budgetary provision and some person akin to that, they are unable to pay the salary. If the democratic set up, every person is entitled to his rightful right, government and any other authority which is entitled to maintain the constitutional provision cannot be allowed to say that they are not in a position to make the payment of that salary. Taking consideration of the totality of the circumstances, it is hereby directed that the area dues with effect from 2001-12-2009 to 30 April 2010 shall be paid by the government to the concerned and all other teachers within 1 month from the date of the government, date from today, and the government and its officers shall ensure payment of monthly salary of teachers latest by 15th of each succeeding month. Respondent number 2 to 7 are hereby forwarded that if there is direction are violated by them, then they will be exposing themselves to serious consequences, including contempt of proceeding. This is the division bench order directing payment of salary, current as well as the area salary. Now, Lordship, I'd like to point out the one thing from the government letter, page 140. In case of one petitioner, whose name also included in the list I have already shown, in respect of one Gopal Kolita. Before that, I will take your Lordship to the original list, name of the Gopal Kolita where it is reflected. Page 97. Lordship will page 96 the list. Original list. Lordship got it, the list. Now Lordship will get serial number 37, Gopal Kolita. Page serial number 37. Gopal Kolita, Lordship got it. Now I'll take your Lordship to the order of the government. From Secretary to the Government of Assam to the Director of Elementary Education Assam. Regarding release of monthly salary of Gopal Kolita, assistant teacher of 169 Kukusua LP School, Shivsagar district. With reference to the above, I am directed to say that from our records, it also reveals that a post held by Gopal Kolita was brought under non-plan with 2759 LP school post, creating post under the non-plan by government letter number Iman. The incumbency is least communicated by aforesaid letter. Already I have communicated, read the letter. Name of Gopal Kolita is enclosed in serial number 357. Subsequently, DI, Nazira, and submitted a proposal for permanent detention of 610 of post of Nazira subdivision, by later number Iman, and name of Gopal Kolita was enlisted under serial number 37. But due to certain reason, posts were not retained permanently. However, temporary retention was accorded, issued annually. Last temporary retention, Iman 2012. In view of the above, report of DO Shivsagar under Iman forwarded to your letter under reference appears to be non-based on facts. Name of Gopal Kolita should not be enlisted. We did 125 access teachers under Shivsagar sub-district at any point, and hence, under no circumstances, monthly salary of Gopal Kolita be stopped since post has already been retained up to 29/02/2012. Same person, Gopal Kolita from Nazira subdivision, his retention already there in the last up to 2012, and including ourselves. We are therefore requested to release monthly salary of Gopal Kolita immediately to avoid future litigation. Further, you are requested to ensure that the matter as how and whose fault name of Kolita has been shown with the enlisted with 1528 access teachers of Shivsagar district and submit a detailed report in this regard within 15 days from the date of receipt of the letter. This is issued by the Deputy Secretary Government of Assam to the Director in respect of Gopal Kolita, whose name respecting 608 teacher. Thereafter, on this basis, letter, Lordship, page 143.
So, the name of the other petitioners are in the list of 1,528 excess teachers of Sibsagar district.
They want to receive on rotation basis. Our salary has been paid on rotation basis to the excess teachers of Sibsagar district. I'll show the document.
Hmm.
We have the retention order from the government for payment of salary. They have decided a meeting, and ultimately Deputy Commissioner and Deputy Inspector of School have decided to on rotation basis to pay the salary with the excess teacher. That is why our salary has been stopped. We are the victim. That is why we have prayed another petition to delete our name from the excess teachers. We are on permanent detention. Government has accorded sanction, and thereafter our salary has been stopped.
So the name of the petitioners are not in the list of excess teachers.
No. Already we have shown the list, Lordship. 610 of list of Nazira subdivision.
Hmm.
Now, Lordship, page 143. On the basis of the letter dated 11 November 2011, page 140.
Page number?
Page number 140 is the letter dated 11 November 2011 from the government to the director. On the basis of said letter, page 143. Director has issued the letter to the Deputy District Administration of Sibsagar. Lordship will find page 143. Government letter number 11/11/2011. Page 143. In respect of Gopal Kolita, page 143. Lordship got it? I am enclosing here with government letter mentioned under reference above, owner to request to kindly release monthly salary of Gopal Kolita, assistant teacher of Purasua LP school immediately. You are also requested to inquire into the matter as how or which fault the name of the teacher has been enlisted along with 152A excess teachers of Sibsagar district and submit a report within 10 days. On the basis of government letter, director has informed the district elimination officer. Originally, at page 144. Original of the said letter is 144. Now, Lordship, petitioner have to again approach the Honorable Court, page 145. WPC number 5031 of 2014. Lordship, in this case also, Lordship dispose in view of the above, present case is disposed of in the line with the observation and direction passed in the order dated 4/4/2014, passed in WBC number 870/2012. Accordingly, petitioner salary and arrear salary should be paid within a period of 3 months from the date of receipt of the certificate code order. That order has been complied with and salary has been paid in compliance of the order. Lordship, I have enclosed the order of the 870 of 2012 at page 148. May I take your Lordship to the relevant portion? Page 157. Page 157.
Yes.
Furthermore, there is also no denial about the specific amendments made by the petitioner. Lordship got it, middle portion. Furthermore, there is no also denial about the specific amendments made in the petitioner in the petition that the respondent number 2 by letter number 1 has directed District Elimination Officer Sibsagar to release salaries similarly situated person to like Gopal Kolita. Lordship got it, Gopal Kolita. Assistant teacher of 176 Kukurmar LP School, Sibsagar district, whose name appeared in the incumbency of 610 teachers prepared by the respondent number 7. In fact, respondent number 2 was directed District Elimination Officer to inquire as how and whose fault name of the teachers had been enlisted with among 1528 of excess teacher of Sibsagar district, thus on the facts so found by me, inference in irresistible inclusion of irresistible that petitioner herein have been subjected to hostile discrimination and hereby illegally and arbitrarily denied their current salary area legitimately to them with effect from 2011. The law is now settled that financial constraint cannot be a ground for the state, which is said to be a model employer, to deny lawful entitlement employees. Or what has been stated in the foregoing, this repetition is allowed. Responding authorities are directed to pay the current salaries petitioner within a period of 1 month from the date of receipt of the judgment. They shall also be entitled to arrear salary and petitioner within a period of 3 months from the date of receipt of the order. Repeatedly, this court has said to pay the regular salary and current salary. That is well up to 2016, they have been paid salary. After 16, again, salary has been stopped. February 16. Lordship, petitioner has filed representation 159 onwards for release of the salary. Page 159 is a representation for release of the current salary as well as area salary. Out of these teachers, Lordship, some of the teachers has already retired from service after attaining the age of superannuation. That is petition number 1, retired from service on 30/4/2020. And petitioner number 2, retired from service on 31/5/2019. And petitioner number 5 also retired, 14 also retired. In the list of dates I have mentioned, Lordship, a person retired from service. In the last page, last portion. Second page.
So four petitioners retired, already retired.
Already. And already, Lordship, I have to point out, the retired person has approached this honorable court for getting the pension, and this court has directed to give the pension to them.
Where is the order?
I'll give the copy, Lordship. They have approached this court, they have been directed to give the pension. Pension has not been released till date, and contempt has been filed. I'll give the number, I have the copy also. Now, Lordship, government has filed an affidavit in this petition. Government affidavit, Lordship, will find page 167 onwards.
Yes.
What they have stated, page para 4 is the relevant portion.
Page number?
Page number 168. May I read, Lordship?
Yes.
Para 4. Petitioner has instituted a opposite petition inter alia praying for deleting their names from the list of excess teacher of Sibsagar district and to pay current salary as well as arrear salary from March 2016. Petitioner claimed to be appointed as a stipended teacher, assistant teacher in the year 1995 by the Deputy Inspector of School Nazira. Although claim of the petitioner is that they were appointed against 610 of posts created under the OBB scheme. However, petitioner have failed to substantiate their claim by annexing any document in support of the genuineness of their appointment. Lordship, I have already shown my genuineness of appointment, showing the list and the name reflected in the list. However, petitioner failed to substantiate their claim annexing any document in support of the genuineness of their appointment. In fact, petitioners were appointed without selection process and then Deputy Inspector of School against non-existence post adhere to the rules. This is against the record which has been substantiated by least annexing the documents. And Lordship, I like to point out one thing. Gopal Kolita also retired from service and he was given pension and everything. He was given full salary till date of retirement. Thereafter, he's been getting pension also. Lordship, in reply to the para 4, we have filed an affidavit. Lordship, reply, Lordship will find at page 184.
Yes.
The statements made in paragraph 4 of the affidavit in opposition is totally false and untrue. From the document of the deponent, it reveals that petitioners were appointed against 610 number of posts created under OBB CSS scheme. Letter of the Deputy Inspector of Schools to the Director of Education Assam in WBC case number demand clearly reflects that petitioners were appointed in the aforesaid 610 number of the incumbency list and they were yearly retention of the post of primary school teachers and the Nazira subdivision. So the statements made in the paragraph number 4 of the affidavit in opposition that the petitioners who had failed to substantiate their claim without any supportive documents is totally false. Same has been made only to mislead the honorable court. Writ petitioners who were originally appointed as a stipended teachers at fixed pay of rupees 900. Thereafter, after successful completion of basic training course, petitioners were regular scale of pay. Thereafter, petitioners' GPF accounts were also open, and there is permanent retention order of the post of primary teachers as per letter dated demand issued by Deputy Inspector of School to the Director of Education Assam. And as such, statements made in paragraph number 4 of the affidavit in opposition that petitioners were appointed against non-existence post adhere to the rules is false and untrue. Lordship, already we have shown the list and communication between the government and the Director of Education Officer Assam that we are appointed on the list and closed. So these statements is without any basis. Now, para 6, Lordship. Page 170. I'm showing them the relevant portion. What are the allegations? Page 6, page 170, para 6. Again, they have showing the name of the access teacher. Page 170. In spite of the fact that petitioner and some other person were appointed in Sibsagar district against non-existence posts, however, government created 1528 of number of supernumerary posts. These are the access teacher, Lordship. 1528 of supernumerary posts under Sibsagar district as a whole, as per order of the Honorable Court, a batch of writ petition by later number demand and temporary retention and budget allocation in respect of 1476 number of posts out of 1528 number of posts were accorded by the government. Accordingly, petitioner received salary up to 29/2016 after creation of supernumerary post. What we have stated, Lordship, we have paid salary up to February 2016. That has been said that supernumerary post has been created and payment has been made. But this is regarding access teacher appointed in Sibsagar district. And these division bench of this court has already stated to take action against the officer who has appointed access teachers. They have not taken anything. And we are the scapegoat. That is why in the writ petition also we have what we have paid. Delete the name of our Lordship will find what we have stated. Lordship will page 18 our prayer of the petition.
Yes.
Page 18. Upon the premises aforesaid, it is prayed that your Lordship may be graciously pleased to admit this petition, call for the records, issue a rule calling upon the respondents to show cause as to why direction will not be issued for permanent retention of the petitioner and to delete the name of the petitioner from the list of access teacher of Sibsagar district. And as to why direction will be issued to pay current salary as well as arrear salary from March 2006 till date of filing of the petition. So our prayer is only basic, Your Lordship, we should not be included the access teacher. Our permanent retention was here and government has created the post and we should get the salary as per list. And same person, Gopal Golita is receiving salary, he is getting pension, everything. But in our case, we have been discriminated. Only to accommodate the Lordship, the access teacher appointed in Sibsagar district. As well as in case of Nalbari also some cases have occurred, access teacher. But in Sibsagar district, Nazira subdivision, our names are reflected, everything has been in order. Lordship, again, I will take your Lordship to the reply affidavit. We have enclosed the document. Page 185. Page 185.
Yes.
Para 4. Statements made in paragraph number 5 and 6 of the affidavit of opposition are also not correct. That petitioner received salary up to year 2003 and 4. They were appointed against non-existent sports is not correct. Letter of the Deputy Inspector of Schools, by which 610 number of teachers appointed in Nazira subdivision clearly disclose the creation of posts and yearly retention of the post of primary school teachers. Lordship, again, Lordship, I will take your Lordship to the page 96 of the petition.
Yes.
Lordship, the OB created height government letter number, this is creation of post, government creation number. The list where we are. This creation number is mentioned in the list. Now, Lordship, again 186. Hereafter, order of the Director of Education, Assam dated Iman, also clearly reflects that the service of the petitioner were brought under non-plan with effect from 1/3/2009 to 28/2/2010. In the year 2013, again by letter dated 9 September 2013, Deputy Secretary Government of Assam, Elementary Education Department informed the Accountant General Assam, Moidamgaon, to convey sanction of Government of Assam for temporary retention of 5472 posts of LP school teachers for the post with effect from 1/3/2013 to 28/2/2014. Thereafter, petitioner have been paid regular salary up to 29/2/2016. Thereafter, authority has not released the salary, though petitioner were holding regular sanction posts because of the inclusion of name of the petitioner with the list of access teacher under Sibsagar district. So statements made in paragraph number 5 of the affidavit of opposition that petitioner were appointed against non-existence post is not correct. Besides this, Honorable Court in WPC case number Iman and Iman already directed authority to pay current as well as arrear salary of the petitioner from the receipt of the certificate with the order. Division bench of this court disposed the analogous cases by order that it directed the authority to that the arrear and dues of the effect from 1/12/2009 to 30 April 2010 shall be paid by the government to the concerned and all other teachers within 1 month from the date of the order of the government, and its officers shall ensure payment of monthly salary to the teachers latest by 15th of each succeeding month. Thereafter, there is no question of further statement in the affidavit of opposition filed by the authority that petitioner were appointed against non-existence post. So my submission to be Lordship, time and again they want to include our name in the access teachers and our salary has been stopped. And already Lordship, the division bench order has attained finality. That order has not been challenged before the Supreme Court, and single judge order has not been challenged before the division bench. And new thing has come to the light, Lordship, now. The government has constituted a high-level committee to inquire regarding illegal appointment of Sibsagar district. What they have stated in this petition, they have constituted a committee, and committee has made an inquiry. Lordship will find page 170.
Yes.
Para 7. In the meanwhile, the issue of illegal, irregular appointed teachers across the state was under consideration of this Honorable Court in various writ proceedings. Honorable Court in such proceeding directed the Education Department to take a call and matter for regulation of irregular, illegal teachers. Accordingly, terms of the order dated demand passed by Honorable High Court in WBC case number Iman, Education Department placed the matter for regulation of illegal, irregular teachers before the Cabinet in meeting held on 26 2011. Thereafter, Education Department proposed to constitute a screening committee to examine the validity of the appointment of teachers who were claiming regulation of the salary. Accordingly, OM dated demand of the screening committee was constituted to examine the case of irregularly, illegally appointed teachers so as to take decision on their regulation and entitlement of salary or otherwise, with a view to examine the selection procedure, nature of appointment, status of post-working status, salaries, academic qualification. Director of Education Assam invited application for these irregular, illegally appointed teachers during 91-2001 through state by an advertisement dated demand and for local newspaper. Pursuant to the aforesaid advertisement, screening committee were received from the irregular, illegally appointed teachers throughout the state who were appointed during 1989 to 91 to 2001. After preliminary examination at directorate level, total 12,085 number of applications were found in order and same were substituted by the government for final verification. Thereafter, Elementary Education Assam by notification that had constituted 5 screening committee headed by divisional commissioner concerned as and principal secretary of 6th schedule area BTC to examine this application and report of the preliminary committee, said 5 screening committee, Upper Assam Division, Lower Assam Division, North Assam Division, Hill, Borak District, and BTC area. Thereafter, divisional screening committee verified all applications submitted on their support and recommendation of review government for further action. However, due to complaints from various corners, government directed to re-verification in respect of the Assam district. The respective screening committee, after causing the re-verification, submitted their report to the government. After verification, the report, divisional screening committee following categories were recommended. Category 1, recommended and working till date 136. Recommended but discontinued 250. Non-recommended but working till date 8470. Not recommended but and discontinued job 2900. In pursuant to the report of the screening committee, a decision was taken to regularize the service of teachers who fall under category 1. Category 1 means recommended and working till date 136. With regard to second category, teachers who were recommended but discontinued their service, the question of the regulation of service and payment of salary does not arise since they are not in service. Similarly, in case of fourth category, since they have discontinued, consideration of their case for regulation and payment of salary does not arise. In respect of 3 category, teachers who were not recommended but still in service, the state government has decided to issue individual show-cause notice to all 8470 candidates and 766 included 752 terminated teachers of Dhemaji and Lakhimpur district, indicating they are in to show the reason as to why their appointment were not deemed to be illegal and irregular, as to why they should not be removed from service on being appointed in violation of the existing rules. This is regarding Lordship Dhemaji and the Lakhimpur district. However, in the meantime, a discussion was held between the Honorable Chief Minister of Education, Honorable Minister of Education and the Teachers Association for irregular illegal teachers as per decision of the meeting as per suggestion of the then Honorable Minister of Education. The department has proposed to take a decision to solve the problem of this irregularly, illegally appointed teachers subject to approval of the cabinet. Accordingly, a departmental committee was formed the government to verify the salary status and the qualification of those category of 3 illegal, irregular appointee. Thereafter, committee has prepared a list. Teachers who have received salaries at some point of time and having JBT and BA delayed degree. The number of teachers included in the list number 1 is 1574. Teachers who receive salaries some point of time but not having JBT or delayed. Teachers who were neither received salaries nor qualified JBT or delayed. Incumbency list number 3 is 7250. Answering respondent beg to state that on the basis of the above list views of various departments, it was decided to solve issue of illegal, irregular appointment by way of preparation of committee memorandum by placing it before the cabinet. Finally, cabinet memorandum. Approval was sought recommending the teachers who have received salary up to 2007 have successfully completed junior basic training course and certain percent of supplementary posts with prospective effect from the date of approval of the cabinet. The post will cease to exist and when the incumbency retired from service of teachers. Now, Lordship, the salary who has received up to 2007 and who has completed basic training, they want to create supernumerary post and thereafter, after retirement, their list will be created. But in this particular case, Lordship, we have received salary up to February 2006. There is no dispute to that effect. And we have completed junior basic training. There is no dispute to that effect. We are not under this, Lordship, the scrutiny. But we have filed application immediately after receiving this notification that our case should be also verified. Lordship, we have accordingly, Lordship, they have verified. Now, para 13. Respondent humbly begs to state that the out of the 14 petitioner, Lordship got it? 13 number of petitioner, 3 number of petitioners, namely Ritumoni Khanikor, petition number 7, Mohendra Gogoi, petition number 10, and Sri Sudarshan Prasad, petition number 14, have been appointed as a newly accommodated teachers with prospective effect on the basis of cabinet approval on 7/10/2020. In respect of Mohendranath Mohanto and Chittaranjan Borgohai, petition number 2, they have participated in the screening process and fulfilled the criteria as laid down by the cabinet memorandum and identified as illegal irregular teacher. However, they could not be appointed as a newly accommodated teacher since the meantime they have attained the age of superannuation on 30/4/2020 and 31/5/2019. What we have stated, that's what we have retired. They have stated. Answering respondent humbly begs to state that remaining petitioner Ajit Kolita, Amulya Datta, Raju Kumar Kaur, Lokeshwar Das, Rameshwar Gogoi, Mridupaman Goswami, and Bolin Chandra Borwa, Basanti Rajkumari did not participate in the screening committee and therefore they could not be accommodated any post of tutor or teacher. Under illegal irregular category, claim of the petitioner for payment of salary is rejected since their initial appointment were illegal. Now, Lordship, in reply to that paragraph, we have stated, Lordship will find at page 188. In regard to this paragraph number 13 and 14 of the affidavit of position, the deponent like to state that Sri Rontumoni Khonikor, petition number 7, Mohendra Gogoi, petition number 10, Sudarshan Prasad, petition number 14, were appointed with prospective effect on the basis of cabinet approval dated 7/10/2020 may be correct. But petitioner do not come under the cabinet memorandum as the cabinet memorandum has an approval to the effect that the teachers who have received salary up to 2007. We have stated that this cabinet memorandum is relating to the person who has received salary up to 2007. It has been further projected that petitioner number Ajit Kolita and Amulya Datta and Kamal Bailu, Rajkumar, Lokeshwar, Rameshwar, etc., did not participate in the screening committee is false and untrue. In fact, the DO Shivsagar by letter dated 15 January 2021 has forwarded the list of teachers who have appeared before the screening committee and their name was dropped out, wherein name of the above petitioner stated herein above alleged to be not appeared before the screening committee with consideration again. Now we have enclosed the list annexure 4. Also, we will find page 231. What they have stated that we have not appeared with the screening committee. 231. Now, Lordship, this is letter from the district education officer to the director of elementary education, Assam Kahilipara. Submission of proposal correction of connection with the appointment of newly accommodated teachers and tutors of various LP school under Shivsagar district who has been dropped out of the list of appointment. With reference to the subject cited above, I have the honor to submit herewith the list of teachers which name had been dropped out as per list declared under the above mentioned letter. Honorable Minister of Education Assam has been endorsed in this regard on the application submitted by Nazira Subdivision Primary Teachers. Proposal has been received from DO as mentioned below. Now, Lordship will see what has been stated, page 232. Bolin Chandra Borwa, Kamal Bailung, Deepak Rajkumar, Raju Kumar, Amulya Datta, Ajit Kolita, Lokeshwar Das, Mridupaman Goswami, Dimbeshwar Purnananda Setia and Basanti Rajkumari. Our name has been subsequently forwarded, originally at page 233. But what they have stated that we have not appeared is also not correct. But this cabinet memorandum is not applicable to us, Lordship. This regard to the person who has received salary up to 2007. We have received salary up to February 2016. And still we are working. No so-called notice, nothing. Terminating our service. No one has got any so-called notice till date regarding termination of service.
Whether this cabinet memorandum is part of the record?
Cabinet memorandum was not part of the record.
Is it available?
Lordship will page 181 is the finding.
79 document of my application. It is a report, in fact, cabinet memorandum itself is not there, but part of the cabinet memorandum is incorporated in this communication lawsuit, which clarifies.
Page number?
Page number 175, 179, sorry. Points of the cabinet memorandum incorporated.
Lordship, we have collected the cabinet memorandum also. We can provide it. Our submission is, Lordship, we do not come under this cabinet memorandum. This is regarding person.
So, in which part of this memorandum it is stated that this memorandum will be applicable to those teachers who have received salaries up to 2007?
Lordship will find. Lordship,
Yes,
the
F. All salaries are
New Education
discontinued since
Department has been
2007.
2007.
F. Clause number F.
Lordship.
Is it?
It's not specified that salary received up to 2007.
Lordship will find. Lordship. Lordship, that is well, Lordship. Page number 3. Page number 3. Approval sought.
Yes.
Approval sought for those who received salary up to 2007,
Up to 2007.
but have not received the professional qualification before 2011. We have obtained Lordship, basic training course
Hmm.
in 2001-2 respectively. In this case, those have acquired basic training in 2011 up to 2011, and those has received salary up to 2007. And Lordship, the division bench orders is holding the fail. That order has not been challenged by the government before the Supreme Court.
Hmm.
And subsequent judgment passed by this honorable court was also not challenged before the division bench.
Hmm.
Now, Lordship, they cannot take a stand that we are come under the access teacher. That is why we have prayed that our name should be deleted from the access teacher of Sibsagar district. Our salary should be paid. And Lordship will find one document I can show that there is a meeting with the teachers of Sibsagar district, with Deputy Commissioner as well as Deputy Inspector of Schools of Sibsagar district, where decision has been taken that to pay the salary on rotation basis. With sanction post we are holding, our salary has been allotted, but they decided to pay salary to the access teacher on rotation basis. That is why our salary has been stopped time and again. So my submission to be, Lordship, we are not included in the cabinet memorandum. We should be paid the salary, current as well as area salary till date of retirement of the some teachers who are working. And Here should be permanent detention and yeah, copy it. Eh. And Lordship, I like to point out one thing. When a judgment passed by this honorable court is not under challenge, it become attained finality. That is established principle. So when the order passed by this court has attained finality to pay current salary as well as arrears salary, when there is no dispute to that effect, after filing contempt petition, they have paid salary up to 2016, February 2016. Now they have stopped. And one judgment of this honorable court I like to place, that is 2017 5 GLJ or GLR, page 83, where this court has held that I'm handing about it though. This court in Usarani Goswami state of Iman, which has obtained the compulsion to waive the arrears salary, claim is a unconscionable and convenient, and such one-sided contention cannot be enforced to deny the arrears salary for regularized teachers. Hence, bearing in mind the ratio laid down in this case also by the Supreme Court in Central Inland Water and Sport Corporation versus Brojo Nath Ganguly, reported in 1986 3 SEC, it is held that petitioners are entitled to arrears salary from August 2000 Iman to month, concluding that respondents are ordered to take necessary steps to disburse the arrears salary of the petitioner for the relevant period. Process for disbursal used to be completed expeditiously as preferably within 6 months, and is ordered accordingly. So we have been working in this school since 1996. We have paid salary up to 2016, February 2016. Again, salary has been stopped. We have to approach in this petition is 2017 also. We have approached after stop the salary, again approach this writ petition 6435 2017. And 2017 still it is pending because non-filing of the affidavit. Ultimately, affidavit is filed by the government. We have also filed the reply and it has come for final disposal. So my submission to the Lordship, we are not included in the cabinet memorandum because this is regarding salaries who were received up to 2007, and those have not completed junior basic training up to 2011. We have completed junior basic training in 2001, and we have received salary up to 2012, 2016. So our direction should be issued to pay the arrears salary and current salary to the petitioner and to delete our name from the access teacher of Sibsagar district.
So, how your names came to be included in the list of that 1,500 and
that is Lordship,
access teachers list?
that has been Lordship. We have stated, the government itself stated in the letter why Gopal Kolita's name has been enlisted the access teacher of the Sibsagar district, and action should be taken against the person who has included the name of Gopal Kolita of the access teacher. This is direction issued by the government to the director. Gopal Kolita's name has been reflected in the 610 number of teachers of Nazira subdivision. Our name has been included in the 610 number of teachers. In respect of Gopal Kolita, they have issued an order not to include his name with the access teacher. Same case we are facing. Our name has been included in the access teachers. In Gopal Kolita's case, government has issued the order. I do not know how this order has been placed in respect of Gopal Kolita, but in respect of others of 608 teachers, government has not issued any letter. But in respect of Gopal Kolita, he is getting regular scale of pay till date of retirement. After retirement, he is getting pension. But we are facing the problem. And Gopal Kolita's letter also will reflect the access teachers has been included. That is why we have said that our name should be deleted with the access teacher.
So you have been appointed in the list of 610 teachers.
Of Nazira subdivision.
Yes.
Except few.
Then how your names are included in the list of access teachers?
Lordship. And Lordship, they already single bench of this honorable court already decided this matter. Honorable Justice Borua has decided the matter. The stipendary teacher, we are also stipendary teacher. They should get this salary and in respect of pension and everything. Already the single bench of this court has already decided the stipendary teacher should get the pension also. But in our case, this is not a pension.
This case is different, Lordship. That pension matter, may I clarify, Lordship, that
I am
pension.
I am clarifying. We are not facing this judgment only on the ground. This is regarding pension. But in case of stipendary teacher, this court has already held they are entitled to old pension scheme, not under a new pension scheme. This has been already decided, and Lordship also decided one case. So my submission will be, Lordship, we should be given salary, area salary, and current salary. And I can give the copy of the judgment when Lordship be required, that if judgment passed by this honorable court is not under challenge, it is in finality, and there is no question of saying anything against
No,
order.
that is settled proposition.
Settled
of,
proposition.
Why is
There-
judgment
there is no
required
question
for
of
that
judgment,
one?
Lordship. That is why I am not brought. Settled principle. So this is my submission, Lordship.
In respect of other petition,
Same thing. Sibsagar district, but we have to file 2 writ petition. Earlier, the 14 number of person has come. Same teachers, same date. Only Lordship we will say in serial number only. Same Nazira subdivision. Lordship, may I take your Lordship to the first annexer 1, same stipendary teacher, page 17.
এখানে here only 3 petitioners are there.
Lordship. They subsequently come to my place. That is why we have filed this case in 2018. Same Nazira subdivision.
You are referring to page number
Page number 17.
70. Yes.
Subject to discharge without any notice, assigning a region, Purnananda Setia, village Iman appointed as stipend teacher and posted at Iman school. Initials, he will get monthly stipend of rupees 900. Subsequently, he will be deputed teacher's training 1 year, subject to available seat. After successful completion of training, he may be allowed to draw regular scale of pay. Thereafter, Lordship, they have completed junior basic training, page 19. Same document, page 19. Junior basic training pass certificate, page 19, in 2001 itself.
$92 is the judgment.
No, page 19,
19.
19.
Okay.
Junior basic training certificate. Thereafter, to regular scale of pay, page 20. In respect of Purnanal Setia. Here, Lordship, 3 petitioners, and they are also same document I have endorsed, and their serial number has been stated, Lordship, it's paragraph number 6.
Page number?
Page number 8 of the petition. May I read, Lordship? That the Office of the Deputy Inspector of School, Nazira, has submitted a list of 610 number of incumbency list for the permanent retention of the post of primary teacher under Nazira subdivision. In the said list, name of the petitioner will be reflected at serial number 596, 576, 563. I can show the list also. List is again start from page 40 onwards. And 596 is petition number 1, serial number. Page number 57. 596, Purnanal Setia, Lordship got it. Petition number 1.
Next.
Petition number 2, 576. 576, page number 56.
$570?
Deepak Rasko.
Yes.
And petition number 3, 563.
Professor Hatemuria.
Dimbeswar Atimoria.
Dispute number 1 and 3 retired.
And other document are relating, I already have shown Lordship.
Same.
And here also 1 and 3 has retired from service after attaining the age of superannuation.
In which paragraph you have stated?
Lordship, after filing his petition, he have retired.
After filing. Petitioner number
1
1
and
and
3.
3.
1 and 3. Hold here. Okay. Again, I am repeating, Lordship. Till date, no so cause notice, nothing. We have not been terminated of service. We have not been released by the government. Our service has been utilized. Apply, Lordship.
Yes, Mr. Sarma.
May, your lordship. Lordship, before I proceed, lordship, may I take your lordship to the memorandum, cabinet memorandum, lordship, which will, your lordship will find in my affidavit in item number 3, 2516 of 2018. Page number 118,
Item number 3.
lordship. WPC 2516 of 2018. Page number
Affidavit.
118.
Annexer.
Annexure. It is annexure A, lordship. Annexure A, page number 118 of our affidavit, lordship.
Yes.
This is a cabinet memorandum. The purpose of constituting the scrutiny committee, lordship will find. Cabinet memorandum, so and so, regularization of irregularly and illegally appointed teachers of lower primary school and upper primary schools by creating supernumerary post or personal post. Now, lots of introduction and background. This is very important. A large number of teachers were appointed irregularly or illegally in lower primary and upper primary schools all over the state during the period 1989 and 1991 to 2001. The petitioners here are appointed during 1995. More particularly in Dhemaji, Lakhimpur, Sibsagar, Kachar, Karimganj, Hailakandi, Bongaigaon, Nalbari, Dibrugarh, Jorhat, Kolaghat, Nagaon, Morigaon districts by some field level officers and school managing committee without following provisions laid down in the Assam Elementary Education Provincialization of Services Act 1974 as well as the rules of 1977. In terms of the Honorable Court's final order dated 2/3/2010, passed in WPC number 1048 of 2004, the Education Department placed the matter of regularization of irregularly teachers before the Cabinet in its meeting held on 26/2/2011 with a view to examine the nature of appointment, status of posts, working status, status of salaries, academic qualification, etc. The Director of Elementary Education Assam invited application from these irregularly and illegally appointed teachers during 1991 to 2001 throughout the state by an advertisement dated 1/2/2012 and 4.
Mr. Sarma, this is cabinet memorandum.
Lordship,
This is
lordship.
not cabinet.
No, this is a back. No, lordship. This is a background because in terms of
This
lordship,
memorandum has any legal sanctity.
lordship, because a one-time measure was taken to accommodate accommodate
You,
the
you saw the cabinet resolution, not the memorandum.
Lordship. Now, Lordship, this is a background, Lordship, how that matter has proceeded for regularization. Now, in response to these advertisements, the petitioners herein voluntarily appeared. So, barring few, voluntarily appeared before the screening committee. Now, Lordship, this is a background, how the illegal and
No,
irregular-
Mr. Sharma, Mr.
Lordship.
Goswami has already shown that they were regularized against sanction posts.
No, Lordship, they were not regularized against census post. My learned friend, which he emphasized about that 610 posts. Lordship, may kindly peruse page number 140 of the writ petition. The communication whereby the temporary post was created,
Page number
140. Letter from the
140 of which petition?
left of the writ petition. I'm sorry, Lordship. That petition, writ petition number, the 6435 of 2017. I'm sorry. I was referring only for that cabinet memorandum, that other writ petition
Regarding Gopal Kalita.
regarding Gopal Kalita, wherein it is specified, Lordship,
Page number
140. Letter from the deputy secretary to the director regarding a release of monthly salary of Gopal Kalita. It is okay. This is regarding Gopal Kalita, but the contents, Lordship, may kindly peruse. I will, Lordship, on the page 140. With reference to the above, I am directed to say that from our records, it also reveals that the post held by Sri Gopal Kalita was brought under non-planning and so and so, so and so, so and so in the incumbency list communicated by the aforesaid letter. The name of Sri Gopal Kalita assistant teacher was enlisted under serial number so and so. Subsequently, DIF school has submitted a proposal for permanent retention. This permanent retention I am referring to. Subsequently, the DIF school Nazira has submitted the proposal for permanent retention of 610 LP posts under Nazira subdivision by letter number so and so dated so and so. And the name of the Gopal Kalita was enlisted under so and so. But due to certain reason, the posts were not retained permanently. So there is no question of permanent retention of these 610 posts because subsequently temporary retention order has been passed, Lordship. So there is no permanent retention of post. So there was a temporary retention, subsequent order. So Lordship, my learned friend is referring to that 610. That permanent retention has not been created, Lordship. There is no permanent retention. Subsequently, there is a temporary retention order is there. Now, Lordship, may I take your Lordship to the affidavit filed by the department, Lordship. Most of the paragraphs my learned friend has already read out, Lordship. Now here, Lordship, how the department went about to accommodate the teachers. Page number 172. Because there were screening committee constituted. They appeared before the screening committee, Lordship. Paragraph number 4 and onwards, Lordship. Page number 168 of the affidavit filed by the secretary, Lordship. Response number 1. Married, Lordship. Page number. That the petitioner has instituted the aforesaid writ petition inter alia praying for deleting their names from the list of excess teachers of Sibsagar districts and to pay current salary as well as arrear salary from March 2016. Because their salary were paid up to February 2016 by creating a supernumerary post, particularly in respect of Sibsagar districts, because the petitioner here hails from the Sibsagar districts. The petitioners claim to be appointed as a stipendiary teacher, assistant teacher in the year 1995 by the Deputy Inspector of Schools, Nazira. Although the claim of the petitioner is that they were appointed against 610 number of posts created under OBB CSS However, the petitioners have failed to substantiate the said claim by annexing any documents in support of genuineness of their appointment. Because if your lordship peruse the appointment letters of the petitioner's lordship, for example, one appointment letter, page number 21, the typed copy. There is no reference as to how these appointments were made, whether any advertisement were issued, whether the due process were followed. Lordship may kindly peruse the appointment order. It is simply stated the subject to discharge without any notice or assigning reason thereof. So and so, village so and so is hereby appointed as stipendiary teachers and posted to so and so school with the following terms and conditions. There is no any reference whether there is in pursuance to any advertisements were made, any due process were followed. There is no statement. Now, Lordship,
No, whether such kind of things are mentioned in the appointment letter.
Lordship, it is mentioned in pursuance to so and so. There are certain appointment letters, those statements are there. Now also under so and so, however, the petitioner have failed to substantiate the said claim by annexing any documents in support of genuineness of their appointment. In fact, the petitioners was appointed without any selection process. There was no selection process by the then DI of school, and the DI, this appointment letters have been issued by the DI of school. By the DI of
Now,
schools
Mr.
against
Sharma,
non-existent post.
that's all right, but there was a direction of the division bench of this court. You show this court what action you have initiated against this person
Lordship,
who had appointed them.
Lordship.
What action you have initiated as per direction of the division bench of this court?
Salaries were paid by creating supernumerary report because their salary were held up initially
No,
from
I am asking
2007.
you what action you have taken upon this person who has appointed them. As per your version, they were illegally appointed.
Lordship,
What action you have taken upon this person?
Lordship, that to that extent against those officials, what action has been taken, that I have to obtain instruction. Because if at all any action has been taken or not, that
So
instruction is
whether
not there
you
with
have
me.
carried out the direction of this division bench of this court?
Lordship, to that extent, I have to obtain instruction against those officials, what action has been taken or not, Lordship. But the matter of fact is, Lordship, these appointments were made without following any due process of law, Lordship, against non-existent post. May I continue, Lordship, or Lordship may rise?
Okay. After 5 minutes.
Lordship. Number 5 of the affidavit, Lordship, page number 169.
Yes.
That the answering respondent humbly begs to state that on being appointed initially, the petitioners had received salary up to the year 2003-4, though they were appointed against non-existent post. In fact, on completion of junior basic training, the petitioners were allowed to draw a regular scale of pay. However, due to shortage of budget allotted post, the salary of the petitioners was stopped in the year 2004 since the petitioners were appointed against non-existent post. It is pertinent to mention herein that the petitioners as well as many such teachers were appointed across the state during 1989 and from 1991 to 2001 without following proper government procedures against non-existent posts, which came to the notice of the government when it was detected that the number of incumbents were more than the total sanction or budget allotted posts. Now, Lordship, paragraph number 6, that in spite of the fact that the petitioners and some other persons were appointed in the Shivsagar district against non-existent posts, however, the government created 1,528 numbers of supernumerary posts under Shivsagar districts as a whole, as per order of this honorable court in a batch of writ petitions White letter number so and so dated 21/1/2009, and a temporary retention and budget allocation in respect of 1,470 numbers of 76 numbers of posts out of 1,528 numbers of posts was accorded by the government. Accordingly, the petitioners had received salary up to 29/2/2016. Therefore, the reason for receiving salary up to 2016 from 2007 was by creating supernumerary post by the order. This is in terms of this honorable court's order in a batch of writ petitions. That in the meanwhile, Lordship, paragraph number 7. That in the meanwhile, the issue of illegal, irregular appointment of teachers across the state was under consideration of this honorable court in various writ petitions proceedings. This honorable court in such proceeding directed the education department to take a call in the matter of regularization of irregular and illegal teachers. Accordingly, in terms of the order dated 2/3/2010, passed by this honorable court in WPC number 1048 of 2004, the education department placed the matter of regularization of illegal, irregular teachers before the cabinet in its meeting held on 26/2/2011. Thereafter, the education department proposed to constitute a screening committee to examine the validity of the appointment of the teachers who are claiming regularization and salary. Accordingly, White OM dated 15/11/2011, a screening committee was constituted to examine the cases of irregularly, illegally appointed teachers so as to take a decision for their regularization and entitlement of salary or otherwise, with a view to examine the selection procedure, the nature of appointment, status of post, working status, status of salaries, academic qualification, etc. The Director of Elementary Education, Assam, invited application from these irregularly, illegally appointed teachers during the year 1991 to 2001 throughout the state by an advertisement dated 1/2/2012 and 4/2/2012 in local newspapers. That, next paragraph, that pursuant to the aforesaid advertisement for the screening, applications were received from irregularly, illegally appointed teachers throughout the state who were appointed during the year 1989 and 1991 to 2001. The petitioners are appointed here in 1995. So they fall under this period. After preliminary examination at directorate level, total 12,085 numbers of applications were found in order, and the same were submitted to the government for final verification. Thereafter, the Elementary Education Department, by notification dated 4/6/2014, constituted 5 screening committee headed by the divisional commissioners concerned and principal secretaries in 6 schedule area and BTC to examine these applications. The report of the preliminary committee, the said 5 screening committee were Upper Assam Division, Lower Assam Division, North Assam Division, Hill and Barak Valley Division, and the BTC area. Thereafter, the divisional screening committee verified all the applications and submitted their reports with recommendations views to the government for further action. However, due to complaints from various corners, the government directed for re-verification in respect of some of the districts. The respective screening committee, after causing a re-verification, submitted their reports to the government. After verification of the reports of the divisional screening committee, the following categories of teachers were identified. There were 4 categories of teachers. Category 1, recommended but working till date. Recommended and working till date. They were recommended by the government and then they were working. 136 teachers. Recommended but discontinued jobs. 250. Not recommended but working till date. These petitioners fall under this category. Category 3. Not recommended but working till date. 8470. Category number 4. Not recommended and discontinued jobs. 2900. Now, Lordship, that pursuant to the report of the screening committee, a decision was taken to regularize the services of teachers who fall under category 1. They were recommended and working till date, and subsequently their services have been regularized. With regard to the second category of teachers who were recommended but discontinued their jobs. So, second category of teachers who were recommended but discontinued their jobs, the question of their regularizations of services and payment of salary does not arise as they have discontinued the job, since they are not in service. Similarly, in case of fourth category, since they have discontinued, considering consideration of their cases of regularization and payment of salary does not arise. In respect of third category, not recommended but working till date. In respect of third category, the teachers who were not recommended but still in service, the state respondents had decided to issue individual so-called notices to all 8,470 candidates and 766, including 752 terminated teachers of Dhemaji and Lakhimpur district, indicating therein to show the reason as to why their appointments are not deemed to be illegal or irregularly, and as to why they should not be removed from service for being appointed in violation of the existing rule. 11. That however, in the meantime, a discussion was held between the Honorable Minister of Education and the Teacher Association or irregular teachers as per decision of the meeting and as per suggestions of the Honorable Education Minister. The department had proposed to take a decision to solve the problem of these illegally appointed teachers subject to approval of the cabinet. However, the departmental committee was formed by the government to verify salary status and qualification of those category 3 teachers. Thereafter, the committee has prepared the list. Now, list 1, list 2, list 3. Now, list 1 pertains to the teachers who have received salary at some point of time and having junior basic training or DLED. The number of teachers in this category is 1574. List 2, the teachers who received salary up to at some point of time but not having junior basic training or DLED. This petitioner comes, these teachers come to 2060. The teachers who neither received salary nor qualified the training, junior basic training, 7,250 teachers fall under that list 3. The answering respondent humbly begs to state that on the basis of the above list and after views of the various departments, it was decided to resolve the issue of irregularly appointed teachers by way of a preparation of a cabinet memorandum for placing it before the cabinet. Finally, the cabinet memorandum. The approval was sought for accommodation of these teachers who have received salary up to 2007 and have successfully completed the junior basic training of DLED or course by certain personal supernumerary personal or supernumerary post with prospective effect from the date of approval of the cabinet. Those posts will cease to exist as and when the incumbent retires from the service. It is a supernumerary post or personalized post. Approval was sought for those who received salary up to 2007 but have not acquired the professional qualification before 2011. Their jobs can only be accommodated as tutor with prospective effect from the date of approval of the cabinet. From the date of approval of the cabinet, those who do not have the junior basic training, they will be accommodated as tutor, and those who receive salary up to 2007 and have a junior basic training, they will be accommodated as a teacher. Paragraph number 13. The answering respondent humbly begs to state that out of the 14 petitioners, now Lordship, these petitioners, that out of the 14 petitioners, 3 numbers of petitioners, namely Rantumani Khanikar, petitioner number 7, Mohendra Goga, petitioner number 10, and Sudarshan Prasad, petitioner number 14, have been appointed as newly accommodated teacher with prospective effect on the basis of the cabinet approval dated 7. This cabinet was approved, cabinet memorandum was approved on 7/10/2020. In respect of now these teachers, petitioner number 7, 10, and 14, their name appeared in list 1, received salary up to 2007. Subsequently, that 2016 they received salary by creating supernumerary posts. So their name appeared in list 1. So training as well as salary, therefore they have been accommodated as teacher. On the basis of cabinet, so and so. In respect of Mahendra Nath, petition number 1, and Chitraranjan Borgoy, petition number 2, though they participated in, because all these petitioners participated in the screening committee. So though they participated in the screening process and fulfilled the criteria as laid down in the cabinet memorandum and identified as illegal irregular teacher, however, they could not be accommodated as newly accommodated teachers since in the meantime they have attained the age of superannuation on 30/4/2020 and 31/5/2019. Because this process was undertaken as a one-time measure for those illegal and irregularly appointed teachers. But unfortunately, in that peculiar circumstances, The petitioner number 1 and 2 could not be accommodated because in the meantime they attained the age of superannuation on 34/2020 and 31/5/2019. So these two petitioners could not be accommodated. Now for the remaining petitioners, paragraph number 40, the answering respondent humbly begs to state that the remaining petitioners, so and so, 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 remaining petitioner lordship, they did not participate. They did not participate in the said screening process, and therefore they could not be accommodated in any of the posts of tutor or teacher because they did not participate. These remaining teachers, they did not participate in the screening committee lordship. Therefore, they could neither be accommodated as teachers nor could be accommodated as a tutor under illegal, irregular appointed teachers, a category of teachers. The claim of the petitioners for payment of salary is rejected since their initial appointments were illegal. Now, lordship, paragraph number 15, more important paragraph, lordship. By the then Deputy Inspector of Schools, without any selection process against non-existence post, dehotes the rules. Rule 3 of the Assam Elementary Education Provincialization Rules 1977 provides the method of recruitment, which provides for a public participatory selection process by issuing advertisement. The select list so prepared by the selection board under Rule 3(1)(b) after completion of the interview of the shortlisted candidate was required to be authenticated by the director before publication of the name. However, in the instant case, no such selection was held as per Rule 3 of the Rules of 1977. Admittedly, appointment of the petitioners in the instant case was made without any sanctioned post, without any advertisement, giving opportunity to all eligible candidates to apply and seek public employment and without any method of recruitment. Be it stated herein that appointments without following procedures prescribed under the rules and without advertisement amounts to breach of Article 14 and 16 of the Constitution of India. It is no more res judicata that the right to salary, pension, and other services benefits are entirely statutory in nature in public service, and therefore these rights, including the right of salary, spring from a valid and legal appointment to the post. Since the very appointment of the petitioners are illegal and are non-est in the eye of law, therefore the petitioners are not entitled for salary as prayed for in the writ petition. Hence, the writ petition is devoid of merit and liable to be dismissed. So, in respect of the petitioners, the status is this, lordship. Now, lordship, in respect of petitioners in another writ petition, lordship, their status in the screening committee, may I specify, lordship? Our affidavit is at page number 106. 2516 of 2018. Here, lordship may kindly directly come to paragraph number. Lordship, paragraph number 13, page number 114. The rest of the procedures are same, lordship. Here, lordship, 114, page number 30. Paragraph number 13. Have a lordship. That the answering respondent humbly begs to state that the petitioners did not participate in the said screening process. However, after the screening process was over, the petitioners submitted their particulars directly to the government. In fact, many candidates claimed that though their credentials were scrutinized by the screening committee, however, their names were somehow left out from the report of the screening committee. Under such circumstances, the department, in order to resolve such similar issues, has decided to hold the screening process afresh in respect of those left out candidates. Be it stated herein that the names of these three petitioners, there are three petitioners in this present petition. The name of these three petitioners in the instant case figure in the database of applicants under illegal irregular category of Shivsagar districts, and they will be screened as per the existing norms followed earlier and based on the fulfillment of the conditions laid down in the cabinet memorandum approved on 7/10/2000, this cabinet memorandum approved on 7/10/2020, their cases will be considered in due course of time. But Lordship, in respect of salary and everything, prior to that, Lordship, the similar status, Lordship. They were also appointed without, against non-existent post without following any due process of law. Therefore, that we have stated in paragraph number 14, Lordship. Lordship, we have authenticated in our annexure also, Lordship, annexure A in page number 179 of writ petition number 6435. This report regarding WPC number 6435 of 2017, Mahendranath Mahanta and 13 others versus State of Assam others. May I read, Lordship? 179. With reference to the above, I am directed to inform you that by the order dated 5/3/2021, the Honorable Guwahati High Court has directed that cases of the present writ petitions be placed before the screening committee for an evaluation as regards the authenticity of their appointment. In this regard, the history of resolving the issue of irregular appointees is placed for consideration that I have already read out in Lordship.
No, where is the resolution of the cabinet? This is only cabinet memorandum. Because we don't know whether this memorandum was approved by the cabinet or not.
Lordship, that approval, Lordship, I will place, Lordship. I may be allowed some time, Lordship. I will place that approval of the cabinet memorandum.
And where is the list of that 1,500 and this candidates who were selected as
So, by creating
irregular?
Lordship. That list is not there, Lordship.
List is with you.
List is not there, Lordship. I will place that list as well as the approval of the cabinet memorandum. That I may be allowed to, let's see, Lordship may fix some other day for in that particular to query, Lordship. That I will place.
Lordship will kindly see 169, writ petition number 2516 of 2018. 2516 of 2018.
Petition number
2516 of
16. Page number
page number 169 regarding the excess discharge. Lordship got it. Page 169. This is a letter from the Office of the Deputy Inspector of School, Najira.
yes.
Lordship, this is from the Deputy Inspector of School to Director of Education, Assam, submission of detailed report in connection of WPC number Kiman. With reference to the subjects, I have the honor to say that Nirupama Sohoria, 6 other LP school teacher of Najira subdivision, has filed cases before the Honorable High Court claiming release of their unpaid salaries 2012. The Honorable High Court, by order dated Iman, where court has directed to pay salary as well as current salary. Main contention of the case is that petitioner is appointed by DDI of School Najira Government Creation Number Iman and Iman Operation Blackboard Scheme in the 1995 for Najira Subdivision, copy enclosed Annexure B. Petitioners were appointed under the said scheme in the year 95-96. As per record received, all the OBP teachers have been drawing salary regularly since their date of joining up to 2003-04, along with the other similar teachers. But in the year 2003 and 4, it was detected that the budgetary allotted to the post of electricity teacher is less than the working teacher in Shivsagar district, as well as Najira sub-elementary block. As a result, drawing and disbursing officer of district could not release the salary of LP school teachers. Teachers Association of Shivsagar district, in presence of Deputy Commissioner Shivsagar, Treasury Officer and DDO of the district, have agreed to receive their salary on rotational basis, what I have submitted. On rotational basis, till this solved the salary problem of by the government. The minutes of the meeting is enclosed in Annexure C, but the finance department has stopped this process in 2006. Right? Finance department copy enclosed. That, sir, while the rotational process was stopped, the salary of all LP school teachers under Sibsagar district could not be paid. Therefore, the matter was informed to the Director of Education Assam. Accordingly, the then Director of Education Assam has directed the DDO and district to release monthly salary on seniority basis of their appointed under. In connection with DO Sibsagar, Bhait ordered that Iman have directed DDO of the district to release monthly salary on seniority and appointment. Copy DO Sibsagar is enclosed in Nazira. Along with DDO, district has released the monthly salary of LP school teacher on seniority on their appointment. In releasing the salary on seniority basis, the budget allotted paid have covered to those who were appointed up to August 1995. Teachers who were appointed after August 1995 have left out and debarred from their monthly salary. Petitioner were appointed in August 1995, so they are left out and debarred from their salary as 1528 number of LP school teachers of Sibsagar district, including 622 number of teachers of BO Nazira were left out from their salary. That, sir, it is pertinent to mention here that annual temporary retention of 610 of OBU teachers against government creation number Iman and regularly name of OBU teachers have been receiving salary against supernumerary posts has been shown annual breakup up to 2014. So DE Assam Bhait later dated D Sibsagar not included the time name of supernumerary teacher and permanent detention proposal of OBU teacher. Accordingly, OBU teachers who has been serving as a supernumerary teacher were omitted from the permanent detention list of the BO Nazira. As such, 76 number of OBU teachers under BO Nazira have been left out from permanent detention list, which was issued by government letter number Iman. That's our OBB teacher along with the teachers have been filed several cases before the Guwahati High Court in pursuance to Honorable Court order created 1528 supernumerary posts at Iman Sibsagar district, included 220 number of posts of BO Nazira to facilitate salary of non-getting salary teachers who had not been receiving salary August 2006. Thereafter, government have again created supernumerary posts in February 2012, release of salary of those excess teachers, copy enclosed. That's, sir, the left out OBB teachers under government creation number Iman, group 610, again filed several court cases, Honorable High Court for release of salary in pursuance to the court's order. Iman government has created 20 number of supernumerary posts and released the unpaid salary. Accordingly, petitioner of the above mentioned cases has already received salary from April 2012 to February 2015 as per budget allotment sanctioned by the government. Petitioner of this case has filed the release of the current as well as area salary 2012 till date. So, Lordship, government has decided, the Deputy Commissioner has decided in a meeting that on rotation basis they were paid. Thereafter on seniority basis to give salary to the excess teacher.
This was of prior to that formation of the screening committee and cabinet
Lordship, that is
approval.
why I'm
It was of 18.5. This communication is of 18.5.
that is 18/5/2017.
2017, Lordship. Thereafter, this further development, subsequent development, cabinet memorandum, cabinet approval, one-time measure. That was subsequent development. This was prior to constitution of that steering committee and cabinet approval. This communication was a
And regarding
prior to
they
that
have
period.
shown that regarding the screening report that this petition number 3 petitioner has not appeared. Page 171. Is a letter from the district implementation officer Sibsagar to the director. That's they have appeared and their name has been dropped out of the list. And Lordship will find page 172. Screening serial number is not mentioned, Lordship. Deepak Rastwa, serial number 6. Lordship got it. Deepak Rastwa. Dimbeswar Hatimura 13. And Purnanda Setia page 15. These 3 petitions. They have appeared in screening committee, but somehow they have left out. And thereafter they have corrected it. And these cases in pending since 2017, Lordship. We have to survive. Because of the slackness of the government, they are not filing a petition, they are taking time. Ultimately, after heavy pressure from the court, they have filed a petition. So this is my submission, Lordship. Our salary should be paid. We should not be tagged together with the excess teacher. And as per budget allocation, we should be paid salary.
Yes.
And Lordship, one thing, I have
Cabinet
made a
appro-
submission that already Lordship, the person who has retired from service and this court has directed to payment of low, it is not related. Provisional pension to be granted, this is the order. Two petitioner has retired from service, I have stated.
To be entitled for provisional pension.
No, this is not a pension, Lordship. The Lordship, I have pointed out that is why I have placed.
To be entitled for pension, Lordship.
No,
one
this
has
is not
to
a
be-
case of pension. This is not a case of pension.
One has to be appointed in a substantive post. In a vacant post.
Highly obliged, Lordship.
Yes.
Therefore, Lordship, my humble submission is, Lordship, these petitioners were initially appointed against non-existent posts without following due process of law, Lordship. So their appointment itself is illegal. So subsequently, the cabinet has decided to provide a one-time measure. So Lordship, I have narrated everything, how the cabinet approval was given and how the screening process was constituted, and these petitioners voluntarily participated in the screening committee, and those who found to be in a list one, these 3 teachers were accommodated, and the remaining teachers, there is no record, and in respect of the other writ petition, their re-verification process will be finalized. So in terms of the cabinet approval, they will be taken care of, whether they will be entitled or not entitled. So therefore, insofar as the arrears salary and other benefits are concerned, Lordship, in this petition, they are not entitled, being a illegally appointed teachers.
No. They have been selected against
And
the sanction post of those OBB.
No, Lordship,
under OBB.
but Lordship, their initial appointment itself being illegal, Lordship.
So they have
Because
also
without following
undergone
a
the
due
basic
process-
training course. Thereafter, their services were regularized. And can you now question that their appointments were illegal?
Lordship. As a result, that the cabinet decision was taken and they were subjected to screening committee, and they were screened and they appeared, they provided, they submitted their credentials,
No, they may appear.
Lordship.
They may appear.
And those who have been accommodated, they accepted their appointment now, Lordship. There is no, they accepted and they are getting salary in terms of the this accommodation order of 2021. Therefore, Lordship, that these teachers, those who have been
There is
accommodated,
also appear that their names should be excluded from the list of 1,528 excess teachers.
that access list of access teacher and that cabinet approval, I will provide, I will place it before the Lordship.
When?
Lordship may fix after on next Monday or any date, Lordship. In the meantime, I will.
On 8 we can try, Tuesday.
What?
8.
Lordship. Lordship.
Only for protection of those documents.
Lord.
Heard Mr. S.K. Goswami, Learned Counsel for the petition. Mr. P.N. Sharma, Learned Standing Counsel for the petition. For other departments, there's a
আছে নি ফাইন্যান্স আছে এতে
and for deputy commissioner,
ডেপুটি কমিশনার গভর্নমেন্ট
where is it?
she was here.
Mr. Soleha, you do not know about the case.
Regarding this matter, it is regarding arrears salary, basically, and that is the education department is the parent department that looks after all these matters. So if they're disputing the claim because they're illegally appointed and so right now finance has no standard. Well, by the next date, they can come up with something.
So, Madam, you are for deputy commissioner. What? But there is an averment in the petition that their salaries were paid on rotational basis. And that arrangement was made by the Deputy Commissioner Sipsagar. Pardon? You have no instruction. So whenever the matter is illegal, then always you have no instruction. Okay. Mr. Soliha for Finance Department and Madam Bormont for Deputy Commissioner Sipsagar. Heard in part, lays the matter on next Tuesday so as to enable Mr. Norma to produce the cabinet resolution and also the list of 1,528 excess teachers appointed in Sipsagar district.
Lot. Obliges. So, respond number.
Permission partner matter, item 4.
Here, I have received the instruction. Well, I'd like to file an affidavit, additional affidavit to bring on this to the record.
When did you receive the instruction?
Yesterday,
Yesterday?
my lord.
Yesterday
I
was
have-
holiday. How you have received the instruction?
Well, through WhatsApp, my lord.
What's up?
My lord. And I have given this price data, my lord.
So next when?
15 days time may be granted.
No.
It's too late.
Next Tuesday.
Yes, Lord.
Heard Mr. Arcidas, learned counsel for the petitioner, and Mr. Bora, learned standing counsel for the elementary education department. Mr. Bora submits that he has received the dias data from the respondent authorities. Then he may be granted some time to file the bring on record the said data by filing an affidavit. Where is allowed, recital is the matter on next Tuesday.
8
April. No?
Can it be on 10th?
Lordship,
Okay, then
Lordship, I'll not available, Lordship. 10.
Then
8 is suitable, Lordship. 8. Lordship.
8.
8, Lordship.
Okay.
Then
Much
9
obliged.
9
9 out of 5. 8, Lordship. Much obliged. Lordship.
Item 5.
Yes, Mr. Das,
Lordship,
any instruction?
till now, nothing has happened for final settlement, Lordship. The process is still on, Lordship. But as on today, I have no instruction that the amicable settlement has reached its finality, Lordship.
No, whether any such attempt is there or not.
Attempt was made, Lordship. Attempt was made. From our side, it's regarding certain materials that which are available with the petitioner herein, Lordship. The certain gold ornaments and jewelries, Lordship. So dispute regarding that they're saying that they are not holding those material ornaments and jewelries. But the respondent husband is saying that he's having. In fact, the list was given much earlier, Lordship. At that point of time, they did not raise any dispute, Lordship. Now, at the time of final settlement, these issues are coming, Lordship. Lordship, what I'm submitting, Lordship may consider the interim prayer, Lordship. So I'll also file affidavit in this case, Lordship.
Yes, Mr. Soike?
But at this stage, my lord, since my lord, the friend is conceding to the interim order, my lord, next date is on 5th. Lordship will steady further proceeding in the suit pending at Dibrugarh. And then perhaps he is also proposing to file.
Heard Mr. P.J. Soike, learned senior counsel assisted by Mr. A.K. Gupta, learned counsel for the petitioner, and Mr. D. Das, learned counsel for the respondent. Mr. D. Das, learned counsel for the respondent submits that though negotiation for amicable settlement is going on, yet nothing could be achieved till date, and as such, he has no objection in the event of consideration of the interim pair made by the petitioner hearing. Mr. P.J. Soikia, learned senior counsel for the petitioner, submits that the next date is fixed before the trial court on
5th of April.
5th, 5th of April. And as such, the further proceeding of PS number
116 of 2024.
116 PS within bracket D number 116 of 2024 pending before the Court of Learned Additional District Judge FTC Dibrugarh may be stayed. Mr. D. Das, learned counsel for the petitioner, respondent submits that he may be granted some time to file the objection. There is allowed recessal is the matter on when?
Lordship, after 3 weeks, Lordship, when he did. Lordship.
After 3 weeks. Then taking note of the submission of learned advocates of both the parties till next date, further proceeding of title suit T number 116 of 2024 pending before the Court of Learned Additional District Judge FTC Dibrugarh stands state. List after 3 weeks.
I'm obliged.
Item 6 matters for orders.
In this case, I am appearing for the appellant, and a claimant has filed an application for direction to deposit the amount 50% of the awarded amount. This is a case of fraud, Lordship. As per GD entry, initial GD entry, an unknown vehicle caused the accident. After 15 days, after 1 month, FIR has been filed before the police station stating implement of nano vehicle. We have exhibited the GD entry as well as the FIR filed by the claimant. So we have to bring on record the Lordship, the affidavit and GD entry, which have been filed before this tribunal, that it is a case of fraud and they want illegal gain by implanting another vehicle. So we have to file an affidavit in respect of the application. We have received the application on 10/1/2025. Lordship, it came to me, my information yesterday evening. So we have to file a reply to this affidavit. Because it is a case of fraud, Lordship.
May I please your lordship, this is not a case of fraud, below. This honorable learned court below has passed this order on the basis of the record and evidence. There is no such evidence laid by this insurance company before the court below to show that it was a case of fraud. It was not a case of fraud.
Lordship, we have exhibited a GD entry number 615 dated 25/11/2025, where it has been reflected. We have to bring on record the GD entry, where it is unknown vehicle caused the accident. Once more. Hereafter, Lordship, present case has been filed implementing another vehicle and claim has been filed against them. Tribunal has ignored the evidence adduced by the opposite party. Because the lower court record is not available in this case, Lordship, now. We have to.
The judgment and award passed by the tribunal has not been stayed by this court.
Lordship. No, stayed. Total award has been stayed.
When?
Appeal was admitted stayed.
Achha.
In miss case number 218 of 2022.
Okay, let them file their objection.
Well,
We'll fix a short date.
let them file, but in the meantime, 50% may be deposited. The learned court below has passed this order on the basis of the search sheet filed by the police. Police has submitted search sheet before the court.
And this court has in another case, Lordship, directed to made an inquiry by the Commissioner of Police regarding the force cases, Lordship. And Supreme, as per direction of Supreme Court. Isn't implanting a vehicle, Lordship?
They have not filed any, they have not laid any evidence.
We have produced evidence.
নাই দিয়া
এইখন দেখাওক না।
difference দিছে but
We have examined Sorbe Shumat as a DW1
yes
and proved the GD entry where it has been stated that unknown vehicle caused the accident. 2 GD entry was made. Next GD entry, one Tata Sumo. Thereafter, one Nano was one
Sorbet
implemented.
was your person.
Our defense evidence.
Yes. That is your employee.
Oh, yes, we have to adduce defense evidence.
The owner
But it is-
owner vehicle is not adduce evidence.
Owner's statement has been recorded that his vehicle was not involved in the
But he
accident.
has not appeared before this court, before the court. He was not
So we
Okay,
file an
okay,
affidavit.
Mr. Goswami, you file your objection, we will see.
After 1 week, Lordship.
Heard Mr. Kedas, learned counsel for the applicant, and Mr. S.K. Goswami for the respondent opposing party. This interlocutory application is preferred by the applicant herein, who issuing direction to the respondent opposite party to deposit 50% of the awarded amount in terms of the judgment and award dated 30/11/2021 passed by the learned member Motor Accident Claim Tribunal, Kamrup M, Guwahati in MSC case number 45 of 2016. Mr. Goswami, learned counsel for the respondent opposite party, submits that he may be granted on time to file objection. S. Fraud has been committed in the MSC case number 45 of 2016, and the evidence so adduced by the witness of the respondent herein were ignored by the learned tribunal. Prayer of Mr. Goswami is allowed. Place the matter on
After 1 week, Lordship.
1 week. Okay, sorted before getting. Thanks.
Obliged.
Then-
Attend 19.
then four.
There's an IA filed by us, my lord, 3788. For allowing the applicants to withdraw the amount deposited by the insurance company.
What is the amount?
It is 1,89,000 pursuant to order dated 3/6/24, 2024, my lord.
Okay, Mr. Goswami.
Lordship, it is a case, Lordship, we do not like to disturb the claimant, but in this particular case, Lordship, as per policy of insurance, vehicle involved in the accident was a motorcycle. And we have annexed the policy of insurance. As per policy of insurance, covered is 1+1, driver and the occupant. Here, Lordship, in this particular case, 3 persons was traveling in the vehicle. Already we have paid 2 claims. This is the third one. As per policy of insurance, we have a liability of 2. We do not have a liability of third one. We have deposited the amount, but if it is released, there is no question of recovery.
My lord, your lordship will
The only-
decide it
Lordship,
at the
only
time
thing is,
of
Lordship,
merit, my lord.
Only thing is, Lordship, if they give a bond,
We
that-
will,
if they give a bond, Lordship, that
Okay,
we will, my lord.
heard Mr.
H. Das.
Is thus learned counsel for the applicant, and also heard Mr. Goswami, learned counsel for the respondent opposite party. This interlocutory application is prepared by the applicant for allowing the applicant to withdraw a sum of rupees 1,89,750 being deposited by the appellant herein before the registry of this court person to order dated 3/6/2024 passed by this court in IA number 102 of 2022. Mr. Goswami, learned counsel for the respondent opposite party submits that he has no objection if the
No,
amount
Lordship may
is
record
released after execution of a bond by the applicant herein. Where taking note of the submission of learned counsel for both the parties, it is provided that the amount deposited before the registry of this court shall be released in favor of the applicant on his executing a bond of equal amount. List the matter. Now, in terms of this, IA stands closed.
My lord, there is a cross objection 13 of 2022 wherein we were directed to take dusty service and we have taken the dusty service. Affidavit is also filed on 7th of March 2024, 2025, my lord. Dusty service. Dusty service को आप लोगों को order दिसे dusty service बोले नहीं कि well, I believe there is also a direction to the appellant to take dusty service. How to make copy one?
We have also taken dusty service, Lordship. We have not getting the feedback from the company. We have taken these steps by dusty.
But my affidavit is before your lordship. We have filed on 7th of March 2025. Cross objection 13 of 2022. What's the record? There is an annexure to the affidavit, my lord.
So, Mr. Goswami, for respondent number 1,
Lordship, I'm of the appellant, Lordship.
for you for the appellate.
Appellant. If notice has been served on
So,
respondent
the
number
cross
4,
objection.
in cross objection, if notice has been served, Lordship, they are also party in the appeal also. Against them, we have also taken steps for service by dusty, but we could not, getting information from the company regarding service. Same respondent.
Well, that is a different aspect, my lord. Let them file their affidavit, my lord, before this honorable court pursuant to the order of this honorable court. They should file, my
Heard
lord.
Mr. H. Das, learned counsel for the cross objector. And also heard Mr. Goswami, learned counsel for the respondent number 1. Mr. Das submits that the cross objector herein has effected service of notice upon respondent number 2 through dusty mode, and to that effect, one affidavit has also been filed on 7th of March 2025. Where is the affidavit? It appears that notice upon respondent number 2 and 3 have been served, but none appears for the aforementioned respondent. No, but the aforementioned respondents remain unrepresented today. Though the notice upon them deemed to have been served. List the matter after when
Lordship will take the information after 2 weeks, Lordship.
2
Because
weeks.
regarding service.
After 2 weeks. In the meantime, Mr. Goswami, learned counsel for the respondent number 1 shall obtain necessary instruction.
Appellate, Lordship.
Hearing items 8 and 9, ordered matter.
In this case, I'm seeking some time, my lord, because instruction not received. Actually, Mr. D. Upamanda was looking after this matter, my lord. He has to left the court due to some medical.
Pardon?
Mr. D. Upamanda was looking after this matter, my lord. He has to left the court due to some personal in medical emergency.
Heard, Mr.
B das, my lord. I'm for item number 9, my lord.
8.
8 for us, I'm not there.
8. After
None appears for the petitioner in item number 8. On call, however, Mr. S.K. Das, learned counsel for the S.K. Das or S. Das?
S. Das, my lord.
S. Das,
Higher
learned
Education
standing counsel for the higher education department, present and submits that this matter is being looked after by Mr. D. Upamanya, who is absent in the court on account of some inconvenience, and therefore he pays for listening the matter after a week.
Yes.
Okay. Accordingly, it is provided that recess shall list the matter after a week. In item number 9, you take down. Heard Mr.
B does, my lord.
B does, learned counsel for the petitioner. And Mr.
Yes, that's one.
S does, learned standing counsel for the
Higher
respondent
education.
authorities in higher education department. Same submission.
There
List
is
the
an interim,
matter
my lord.
after 1 week. Why both the matters were take together?
My lord, as per my information, my lord, with in item number, my lord, in item number, my lord, 8, there is an order to actually to recover some amount, and pursuant to order of this honorable court, one notice was given to the petitioner of item number 9, and challenging that, my lord, he has approached this honorable court.
Recovery of
Some amount,
excess.
some amount, yes, my lord.
So is it permissible?
It is not, my lord, as per Rafiq Masjid, it is not permissible, but since this order has been passed pursuant to my lord, court order, that was the, my lord, stand, actually our stand. That order has been passed by the authority pursuant to the order of this honorable court, my lord. Because during deliberation of the matter in item number 8, my lord, some anomalies were found, and it was found that some amount has been illegally given to, my lord, some petitioners. I think some persons, my lord, including these petitioners. Then this honorable court has asked the authority to take some steps against those persons, and pursuant to that order, authority has sent some so-called letter, my lord, to those persons, and petitioner in item number 9 is of that, my lord, challenging the recovery. We'll bring this affidavit, my lord.
There is a decision of Supreme Court that
Rafiq
that
Masih
cannot
is,
be
Yes,
revoked.
after 5 years, my lord, it is not permitted. After 5 years, it is not permissible. Pursuant to
yes, my lord, Rafiq Masih, as per Rafiq Masih, we'll file affidavit, my lord.
Okay,
As
then
per
on-
what,
After a week, recess shall list both the matter as parted.
My lord, in item number 9, there is an interim, my lord, that may be extended.
Interim order passed earlier shall continue. Item number 9.
Okay.
11. Item 11.
So this matter kindly be taken at 2 p.m.
Why?
My senior is as
Who is your senior?
Mr. T.J. Mohanto. We are for the respondent.
Yes.
And for the appellant, Mr. James Sarah, the senior advocate who is in this case, is just coming in 2 minutes.
Who?
James Saiwala.
Okay. At 2 o'clock then.
Item 14.
Great teacher, Lordship. I'm from the for the defendant.
You are for the respondent.
Respondent, yeah,
You
myself.
are legal aid counsel. But the appellant is absent today. None appears for the appellant on call. How about Miss R. Dotto? Learned legal aid counsel for the respondent present. List the matter after 1 week. In the event of subsequent non-representation of the appellant, appropriate orders will follow. Madam, take a date from him. This is all matter.
Item 16.
None appears for the appellant on call. None appears for the appellant and respondent on call. Record shall list the matter after 2 weeks.
Item 20.
Mr. Goswami, are you ready to argue the matter?
Yes, yes, Lordship.
Okay, then we will start it immediately after one RSA is there. We will start it at 2 o'clock.
Yes, Lord. I'm ready.
Mr. Sayola, please come at 2 o'clock.
Yes. Item 11.
My lord, a suit was filed by one Manju Pal for eviction of the defendant. Her claim is that he purchased the suit land on the basis of a registered sale deed executed by a attorney holder, whose attorney was notarized attorney by the owners. So point here in this case is this, my lord, the trial court decreed the suit, appellate court reversed it. Appellate court reversed on two grounds, my lord, that the power of attorney is not valid. Secondly, they have adverse position. So for adverse position is concerned, my lord, there is no pleading at all. My lord, that time, but only point is this, my lord, the power of attorney. Now, finding of the trial court, if your lordship will find, my lord, without going to the other facts, issue number 4, page 61.
Trial court has decreed the suit.
Decreed.
Appellate court reversed it.
Reversed it on 2 points. That power of attorney is not valid. Secondly, they have adverse position. Adverse position plea is not there, pleading is not there, my lord. So far defendant is concerned, that I shall place only the pleadings that will do. Now, the main point is this, my lord, power of attorney, because it is not a, it is notarized public power of attorney. It will definitely. Adverse position is not. My coach.
Yes.
Now, your losses may turn to page 61, my lord. The trial court judgment.
Yes.
In this regard, the learned counsel appearing for the plaintiff submits that power of attorney was executed by the heirs and successors of the original owner of the land in question. He submits that power of attorney duly executed by them in favor of defendant number 6, who is the husband of the plaintiff. He submits that power of attorney was executed before notary public on 13/8/97 in accordance with law, and therefore it is clear that the said power of attorney is marked as exhibit 6 was lawfully met. On the other hand, learned counsel appearing for the contesting defendants submits that power of attorney was signed by the only by the late Bhavesh Chandra Mukherjee, Suresh Chandra Mukherjee, Umesh Chandra Mukherjee. Said power of attorney was executed by the heirs of Naresh Chandra Mukherjee, who is owner of the suit land, and the property is standing under the municipal holding number so and so. She also submits that power of attorney is also not legally tenable, as the said power of attorney of the defendant number 6 sold land to his own wife. Power of attorney means the document by which the executor empowers another to do a job, as may be mentioned in the instrument itself. By giving enforceability of such type of document, the instrument is required to be certified before the notary public. It appears the document marked as Exhibit 6. The power of attorney was executed by the heirs of late Bhavesh Chandra Mukherjee, Umesh Chandra Mukherjee, and Suresh Chandra Mukherjee before the notary public at Kolkata, West Bengal. The power of attorney was duly certified by the notary, which bears the seal and signature. Now the question remains whether the said power of attorney the executors thereof can empower the defendant number 6 to alienate the disputed property or not. The executant of defendant number 6 are not absolute owners of the suit land and property is the disputed question herein. However, exhibit 7, which is a declaration made by the heirs and successors of late Naresh Mukherjee, it is clear that affirmed that the sale of the land and the structure thereon made the plaintiff. By the said declaration, the heirs and successors of late Naresh Mukherjee also declared that they have no objection on the sale already made. As stated above, although the defendant challenged the authenticity of the power of attorney as well as the declaration marked as Exhibit 7, yet he did not endeavor to call any of the executant defendants or the notary public. Page 61 of the internet. Exhibit 7 in to the substantiate the power of attorney or the declaration was not made in accordance with law. The usual documents and the evidence adduced by the party, I do not find anything to hold that the same is executed in condemnation of law, and therefore I am of humble opinion that so and so partially good. My lord, this is the finding of the Learned Trial Court. Now, my lord, the appellate court in ground number 3, my lord, it has been taken up at page 20.
Page number 20.
Page no 20.
So the
My lord, main question
trial
is
court,
this.
trial court has relied upon this power of attorney.
Power of attorney which is notarized, my lord.
Notarized.
Notarized.
Not registered.
Not registered. That is the only question, my lord.
Whether it can be relied upon or not.
Yes, that is the, my lord. My lord, the appellate court finding, my lord, you will also find. I'm just coming, my lord. Page 20, My lord, your losses may just come to page 27, my lord. But very long finding. I know. On going through the second para, evidence of the power of attorney holder, P2 to Tapan Pal, he has admitted that the attorney holder cannot use
Page
the
number?
Page 27, second paragraph.
Page number 47.
27.
27. Okay.
On
going
going
through.
evidence of power of attorney holder, P2 to Tapan Pal, he has clearly admitted the attorney holder cannot use the power of attorney to him by principle in his own interest or in his own favor. P21 is a plaintiff tried to establish the power of attorney exhibiting the documents named Exhibit 7, the declaration made by late Naresh Mukherjee. But the same has no value in the eye of law. Therefore, the trial court ought not to have accepted the evidence by the plaintiff witness. Further, PWT Sandeep Ranai, who is also the witness of the power of attorney holder, he stated in evidence that he had not put any signature on Exhibit 6. He further stated that even he did not know the principle of the power of attorney, hence Exhibit 6 is not valid in eye of law, so authentication done is not doubtful. Further, Section 34 registration imposes upon the registering authority the duty of inquiring as to due execution of the document, and by Section 35, registered document on being satisfied at various particulars mentioned therein. Authentication is more than mere execution, and one of the person designated in Section 85 for the purpose of presumption of the power of attorney to be a party. The authentication must be clear, specified, decisive endorsement by notary public. In a power of attorney shown by him, raises presumption that he must be satisfied himself discharge of official duty, and the person executing it was for the person, power person. In decision of the division as so and so, It is held that presumption under section 85 should be on two occasions. The first is the document should have been executed by notary public, and second should be authenticated by notary public. In our case, executed by the notary public and has also been authenticated by notary public, but a power of attorney has agent or power of attorney has put his signature in the document. So section 85 as well as section 34 of the Evidence Act has not been complied with. It cannot be presumed that authentication was done. Attorney holder cannot use the power of attorney given to him by the principal in his own interest or in his favor. People one who is the plaintiff tried to establish the power of attorney by exhibiting the document named Exhibit 7. The declaration made by the heirs of late Reston Mukherjee, but the same has no value in the act law. Therefore, trial court ought not be accepted here on the evidence of the plaintiff's witness. Further, period 2-3. Sandeep Pranay, who also witnessed the power of attorney, Exhibit 6 clearly said that in evidence that he had not put any signature on the Exhibit 6. He further stated that even though he did not know the principle of the power of attorney, hence Exhibit 6 is false power. Considering the act of trial court declared Exhibit 6 power of attorney as illegal, but cannot act upon, and they are so the attorney holder in terms of 6 illegal and void. Since power of attorney is illegal and has no value in the act law, the entire case of the respondent is based on the aforesaid power of attorney. The respondent's suit is not maintainable and liable to be dismissed. And point number 4, framed in this appeal from the issue, both suits are declared illegal, so and so. Why administrative goes against this one, the finding of the power of attorney towards the ground of appeal, trial court so and so. Well, this is the finding. Well, actually, my lord, the difficulty is this, my lord, the power of attorney is an notarized, my lord, not a registered. That is the my difficulty is this, my lord. That no. My lord, virtually, the law is this, my lord. I must consider that for exhibiting a registered document of immovable property, the power of attorney should also be registered. Virtually. That is the law, my lord. So, my lord, this point, my lord, this is the my lord, if your lordship find, my lord, that having the law, my lord points, whether learned lower appellate court committed error of law in holding that persons of power of attorney cannot be presumed under section 85 of the Evidence Act in absence of signature of the Evidence Act. But that is not the point at all, my lord. Virtually, the power of attorney should be registered, in fact, my lord, and my lord.
Not only that, my lord, that power of attorney, that main point is, my lord, after reading all the paras, then it will be clear. The power of attorney given by whom? Who has the power to give that? Entire, my lord, share, entire property, my lord, all the members are not signed that power of attorney. Only by the 6, all the legal heirs are not signed. Only by that, my lord, only by 6 persons, there are 15 legal heirs. Only by the 6, my lord, they have given a power of attorney that could not register, and that power of attorney holder, my lord, sell that land to his wife.
That can be done. There is no difficulty, my lord.
So that's why
that can be
that
done.
mean the appellate court judgment very clearly mention it, my lord, and very elaborately discuss it, my lord. So, my lord, there are 2 suits. There are 2 suits, my lord. In fact, there are 2 suits. One filed by us, and as a counter to that, he has filed, and that both that 2 suits are, my lord, by a common judgment, it was disposed of, and then, my lord, in appeal, my lord, it was both by a common judgment, my lord, it was reversed, my lord. So now, my lord, question is this, my learned friend, my lord, asks me whether it can be, my lord, settled outside the court or not. If, my lord, outside the court, my lord, I am concerned with my part. My part is, my lord, one katha 7 lakhs. If 1 katha 7 lakhs as decreed by the learned trial court, the appellate court, if it is keep intact, my lord, other, my lord, I have no objection. His claim is 3 katha 14 lakhs. By virtue of a registered sale deed, or by virtue of a power of attorney, which was now declared by the learned trial appellate court that is illegal, and registered sale subsequent also, the registered sale also goes, my lord. So, my lord, my submission, we should If your lordship, my lord, my already decrees in my favor, my lord, one kata, I am interested only 1 kata 7 lakhs. So if it is keep intact, my lord, other, my lord, I have no. But that has to be, my lord, modified, my lord, by way of, my lord. There is a settlement by both the parties. For that, my lord, we have to, if that is his proposal, my lord, he just told me that fair and submitting. That was, my lord, made it, I was ready to argue.
My lord, let it be kept part heard, my lord. Let it be fixed in the next week. I shall take instruction from my
lord,
I shall take instruction from my client, and that matter can be disposed of.
Okay.
So my adverse person is concerned, there is no adverse person. My lord, that I'm not going to that also, because if this point is decided, then. So I think on the.
I'm not interested for whole land. I am interested only 1 kata 7 lakhs. He is interested for whole land. But that is total land is 3 kata, I think.
3 kata something.
3 kata something. 3 kata 14 lakhs.
14 lakhs.
Okay. So suggested that then?
My lord?
Suggested that.
Well, next week any date, my lord. 8th of my lord. Sure, after view. After view also.
After view, let it be after view then.
Yes, my lord.
Okay. 8.
Well, let it be part heard.
After view. Part heard.
Part heard. My lord, because that will be better. Because if the instruction comes, my lord, that can be disposed of on that point.
Okay.
This point.
Heard Mr. G. N. Sayola, learned senior counsel assisted by Ms. Learned counsel for the appellant, and Mr. T.J. Mohanto, learned senior counsel assisted by Ms. P. Bhattacharya, learned counsel for the respondent. Heard in part, list the matter on 24th of.
After view, yes, my dear. No problem.
As part heard.
Standing item 20.
Next is your lordship. I'm not on very strong grounds.
You have always strong grounds.
Lordship?
You have always strong grounds.
No, I'm not on nice.
Because you were the appellant.
Yes. Lordship, I filed this appeal on 2 grounds. One is on multiplier, the other is on, I filed an additional application also. But evidence will not be.
Is it as per the decision of Sarla Verma?
Yes. Okay. Lordship, I filed this against the settled position. I have a slightly different point of view, which is I filed this appeal. I will not make it long, Lordship. If I'm
you first answer me whether the tribunal has relied upon the
yes, Lordship.
Decision of Sarla Verma while this
as well as pronounce it here, I believe it's a judgment of B.
Yes.
It has to rely on both. So it is relied on Sarla Verma. And also it should have relied on pronounce it also.
What is the age of the? What was the age of the?
It is there is no controversy about that selection. I mean that whether it is inaccurate or I'm just only on the point of principle, Lordship. Earlier, Lordship, before Sarla Verma came, it used to be the age of the deceased or the claimant, whichever is had. That was a law for 14 years, Lordship. From 1994 to 2009. Almost 14, that was the law followed by all courts, including Supreme Court. And that was judged by a 3-judge bench. The whole objection I take to this
Is this
No,
a
no,
two judge bench?
this, the decision of Sarla Verma was endorsed by the Pranay Sethi.
That is
Decision
my
of Pranay
point,
Sethi.
Lordship. It has not discussed this point.
Hmm.
It just said in general,
No, maybe.
it's just,
No,
Lordship.
no. Mr. Goswami, you see, be it right or be it wrong.
Yes, Lordship.
But we are supposed to follow the decision.
I know, Lordship. That's why I initially said, I'm not on strong ground, Lordship. But since I have a point of view, I know these limitations of the courts below the Supreme Court. Also. If Supreme Court has said something, the High Court has to follow that.
Follow it, yes.
Yes, Lord. It's only with this. I'd like to, Lordship, just to support it, let it be on record, a small submission, Lordship. I'm giving a copy to him, but I know the, Lordship, outcome, Lordship. Just to be on record, Lordship. So, the other ground, Lordship, I'll not dwell on it, this Lordship. Lordship will have to follow the Supreme Court. But I have a point of view. I just want it to be on it. The underground, Lordship, is on the ground of fake deal. What had happened, Lordship, the Appellate Insurance Company had filed a review application. I have annexed the order there. On the ground that in spite of giving instruction to the advocate has himself said this in it. The license was fake as confirmed by the DTO. That was not, no evidence was given before the tribunal. And when the review was filed, review was Lordship rejected because it's, as per the tribunal, Lordship, some dates were given, opportunities were given to the insurance company to file evidence, but they did not do so in time. And that, Lordship, was rejected. I filed an application under Order 14, Rule 27 to take that into consideration.
To take?
Just to have a look at the time of hearing, Lordship, or the additional evidence in appeal, Lordship. Because, Lordship, insurance company had given evidence to the effect receipt of the instructions by the advocate. And
Where is that petition?
And that application is there. If that is taken into consideration, I can at least, Lordship, pray for a relief of pain recovery. 1037, Lordship. I see 1037. Annexure 1 is the confirmation given by the that they had stopped issuing any such license from a long time back. And therefore, they have said this license is not issued by the Office of DTO Ukhrul District. It is clearly a fake license. In the review order, Lordship, I have annexed it my Lordship.
Where is that order?
Review order is, Lordship, in page 18 annexure of my Lordship. Memo of appeal. Yes, Lordship. Page 18.
Page number?
Page 18, Lordship, 18. Order dated 13/1/21. It's a mistake on the part of the counsel advocate, Lordship. That also gives a ground for review. It's on a wider Lordship.
No, Mr. Goswami, you see, on what ground the review petition can be admitted is well settled.
Mistake of fact by the counsel is also a mistake of fact. Yeah. That is also one of the grounds, Lordship. And any other sufficient reason covers that part, Lordship. In fact, this is, Lordship, there is a judgment, I not have it, BCCI versus Netaji Subhash Chandra Bose Club. That gives a very wide interpretation. It includes, Lordship, even mistake of fact by, the council was under a mistake of fact and he did not argue that particular. Or I mean, this is a case where the council has very clearly said his junior had received the instructions. In fact, I have a copy of the E also. And yet he could not file it. That is a mistake on his part. And in this case, the owner and driver were, I think, heavy expert. Yes. Owner and driver were expert in law. Yes.
The review court has rightly rejected your petition. Now in the appeal, you cannot file. You cannot advance the same prayer
Lordship, only
in a different form.
yes, Lordship.
In a different
My
form.
point is that it could have been allowed, Lordship. It is a mistake of fact that clearly the advocate has admitted in his review petition. And Lordship, that it was on his fault. His junior had received it and but did not give it to him. That kind of thing. So insurance
Unless you
company had
challenge
advised, in fact, to file an additional written
Mr.
statement.
Goswami, unless you challenge the order dated 13/1/2021, this petition cannot be considered now.
But I had filed it as an EL, which is why I have mentioned it in the memo.
So we are dismissing this application. You argue the appeal on merit.
This.
Yes, come to your memo of appeal. What are the grounds?
Grounds, these are the exactly, Lordship, these are the grounds that I had spoken about. One is that multiplier, the other is the EA, Lordship.
License.
Fake license. These are the only two grounds. It's a
If the tribunal has selected the multiplier as per decision of the Sorla Burma, then the same being endorsed by the Supreme Court constitutional bench in the case of Pronoy Setri, this court has nothing to do with the multiplier.
in spite of that, Lordship, I just wanted to place my argument because I very strongly believe I'm very firm in my conviction, Lordship, that
Mr.
that was a different point of view could have been taken. Because Lordship, what had happened? It's if I can, Lordship, permits me to discuss.
This is not the forum to deal with that argument. Mr.
Yes.
Goswami, you may go to the Supreme Court.
Knowing full well, Lordship, the limitations of this honorable court, Lordship.
That decision
There is a binding nature of the Supreme Court decision.
Yes.
I knew it full well.
That decision is also to be reviewed by another constitution.
Yes, Lordship. I'm fully, which is why, Lordship, this goes through my argument. What has happened, Lordship? If Lordship permits, informal, Lordship, I'll just make it. There's a raising controversy in the country, Lordship, before Pranay Shetty came into being. What will happen if I'm allowed to? I know this, your Lordship will have to go by the Pranay Shetty. In 1994, Sushma Thomas's decision was which made multiplier as the only method for calculation of compensation. 1996, Sushma, there's this UP Trilok Chandra versus UP SRTC, Lordship, Uttar Pradesh State Road Transport. 96, that was a three-judge bench, Lordship. It is subsequently endorsed by another three-judge bench, Kailasan versus Santi. And Lordship, at the top of, from the top of the judiciary, Lordship, it was said that there is the only method the courts will follow. And Lordship, the precedents, the law of precedence says, even Supreme Court is bound by its own decision of a equal bench, coordinate bench, not to talk of going against under higher bench or even lower. So this was the rule from 1996 to 2009 when Sarla Verma came into it. The judgment was pronounced. In Sarla Verma, it is two judge bench. It could not have said anything against the three judge bench. I know from 2009, Lordship, I've been filing appeals on this ground alone. From 2009. What happened was this three judge bench, Sarla Verma did not in fact discuss why, could not have discussed. It could have referred it to the higher ranks. The principle earlier always used to be, it was the only principle in the entire arena of compensation, Lordship. Rest are all thumb rules. 1/3, 1/4, 25%, 33%. These are all thumb rules. These are not indicative of a principle. Underlying principle, yes, the older person, the lesser is the multiplier. That used to be earlier. The earlier formula of the multiplier shall be as per age of the deceased order claimants. In general, Lordship, when the husband dies, he judges the highest. In case of bachelors, there is an exception. It's the person who dies is always, he judges lower than his parents or whosoever else claims. In case of bachelors. In case of married person, that rule will apply. The age of the deceased is higher. Is the father, husband, whatever it is. So an exception was made that in case of bachelors, this will be the age. Higher age of the deceased out of whichever is higher. So it used to be that for bachelors, the age was used, applied as per age of the parents. Not his. Because the logic, if your Lordship, I'll just pray, it will be a very long argument, Lordship. I've put everything in writing in that. Lordship will understand. So, no, but the point is, once, Lordship, I had to, because as I think the Delhi High Court had different point of view. High courts in the country had different points of view despite this Sarla Verma. Some said no three judgments, Triloksandra will. They, in fact, their judgments of Delhi High Court also, a big judgment, HDFC organization versus Lota. So when this matter was discussed, this arose out of a different three judge bench decision, not on multiplier at all. This was Resma Kumari versus Madan Mohan. That was one case when the Supreme Court had to decide on another point, not on this. And Lordship, from para 18 to para 33, Supreme Court discussed the point of binding nature of precedents. The law of precedents or binding nature of decisions of the IA. It is exactly on this point, Lordship, once I was referred to the division bench. The Chief Justice, in fact, asked me. In fact, there are two contradictory, at that point of two three-judge bench decisions. One is Triloksandra. The other used to be three-judge benches. After Sarla Verma, some other three-judge benches followed Sarla Verma. They also echoed the same way, but which was in contradiction with under three-judge bench Triloksandra. That is the landmark decision that was it. So once in similar EL also, because of when I pointed out some judgment of this High Court also, that single judge benches had different point of view, as referred to the division bench. The division bench Lordship asked me, this asked me in fact. He said, tell us when there are two equal bench judgments, what we as a High Court should do. I said, my lord, until and unless the previous one is overruled, the law precedent says I follow the earlier rule. But Lordship, what happened after a long discussion? It was that the Supreme Court at that the pronunciative was not there, but Rajesh versus Rajbir was there, Munna Lal Jain was there. So for the moment we will go by the latest. Yes, of course, yeah. That was discussed in that controversy was discussed. What I had, my contentions were discussed in pronunciative para 18 to para 33. This is all about what they. From that point of view, someone at that point of view, at that point of time, had pointed out to the Honorable 5 Judge bench, Lordship, that Sarla Verma was a lower judge. maybe the result would have been something different altogether. The Supreme Court would have had a different look at it. Because it was accepted, no one pointed out the controversy. It was accepted. The Salama could not have overruled her bench in any. So that is being persisted with us. In my point of view, a mistake was once made and it's still continuing. So I always feel very strong, confident about my point of view, but I have to also, Lordship, follow the same.
No,
Once this
Mr.
occasion comes,
Goswami,
Lordship, I just try to put my point of view across. That's the only thing
No,
I
no,
can do.
Mr. Goswami, you are representing the insurance company.
Yes.
Why don't you file a review petition before the Supreme Court to review the non-executive decision?
Maybe some such opportunities will give an opportunity to do again.
Because
Once probably it has to be challenged, Lordship.
Pranay Sethi has endorsed the view of Supreme Court in the case of Sarla Verma.
Lordship, there's not a single line discussion on it. It says judgment pass sub silentio. The principle of sub when even the Supreme Court does not have the power to pass an order without a discussion. There's not a single line discussion on this particular controversy, on this particular point.
No, there is
It's a
some
very
reference
detailed.
to- no, no. Mr. Goswami,
Yes, Lordship. It has
there
to
is
be
some
challenged.
reference
One-
to Sarla Verma case in the Pranay Sethi decision.
Chalo.
Some reference was there. Yes.
Lordship, I'll read out. No, that point was not discussed. It's just, it's say.
No, that
Because
point
Lordship,
was not
multiplier-
discussed, but the Pranay Sethi case, in the Pranay Sethi case, it is stated that the
since the law is well settled,
multiplier, yes.
laws are well settled as
yes.
per para 19 of Salabama decision,
Has to-
read with para 42, that was the only thing. That principle that there has been a violation of Triluk that is not discussed. The Salabama could not have, even if for it, maybe a Pranay Sethi can do it. Pranay Sethi's judgment can do it because there are 5 judgments. Salabama at that point of time did not have the authority of law, Lordship, if I may say so, to overturn a decision of the higher bench. But somehow this point was not raised, that Delhi High Court is following, has
Okay.
passed a different case.
Okay. Except this 2 points, you have no other point.
No other point. But I'll be happy, Lordship, your Lordship gives a minute or two my write-up, Lordship.
Okay, we'll go through it. Yes, Mr. Kishan.
I'll be very Lordship, that the regarding fake driving license, Lordship, I am relying on the judgments which I already given the copy. Lordship, one is reported in 2013 10 SCC 217.
2013.
10 SCC
Yes.
217. Pepsu Road Transport Corporation versus National Insurance Company, Lordship. I am relying on para 7, 9, and 10.
Yes.
Yes, Lordship. May I read it, Lordship?
Yes. 7.
Yes, para 7, Lordship, of the judgment. Swaran Singh's case Supra has subsequently considered by 2 judge bench of this court in National Insurance Company versus Lakshmi Narayan. It was explained that mere absence of fake or invalid driving license or disqualification of a driver for driving at the relevant time are not in themselves defense available to the insurer against either by the insured or the third parties.
You are reading paragraph number 7.
Yes, Lordship.
Yes.
Lordship has got.
We may extract the relevant paragraph.
Yes, yes.
From judgment in Lahiro case.
Yes, yes. I am relying on the Lehru also, Lord.
Yes. Okay.
Lordship has is holding Lehru's judgment, I suppose, or the Pepsu.
No, this is Pepsu.
Yes, and Pepsu, Lordship, paragraph 7. In internal page number 5, Lordship.
All right.
May read, Lord. Mere absence or fake or invalid driving license or disqualification of a driver for driving at the relevant time are not in themselves defenses available to the insured against either the insured or the third parties. To avoid this liability towards the insurer has to prove that the insured was guilty of negligence and failed to exercise reasonable care in the matter of fulfilling the condition of the policy regarding use of vehicles by duly licensed driver.
No. Which paragraph you were reading?
Proceed.
In Pepsu RTC. Pepsi RTC versus National Insurance Company. In this case,
Yes,
paragraph number 7.
7, Lordship.
Yes.
Starts from Saran Singh's, the word Saran Singh's case within bracket Supra.
Okay.
And the pay will be.
Acha. Paragraph start from? Nine.
I have downloaded my copy from legal, but this copy was
Okay,
not
all right,
from the
all
bar, Lordship. Have Lordship got it?
Yes.
Saran Singh's case, Supra was subsequently considered by two judges bench of this court. We inverted comma Lordship. Mere absence of fake or invalid driving license or disqualification of a driver from driving at the relevant time are not in themselves defenses available to the insurer against either the insured or the third party. To avoid its liability towards the insurer has to prove that the insured was guilty of negligence and failed to exercise reasonable care in the matter of fulfilling the condition of the policy regarding use of vehicles by duly licensed driver or one who was not disqualified to drive at the relevant point of time, at the relevant time. Now, Lordship, in another judgment was Lordship was about United Insurance Company versus Leheru, reported in 2003, 3 SCC 338. Para 20, or Lordship, last third paragraph of the judgment. Yes. When an owner is hiring a driver, he will therefore have to check whether the driver has a driving license. If the driver produces a driving license which on the face of it looks genuine, the owner is not expected to find out whether the license has in fact been issued by a competent authority or not. The owner would then take the test of the driver. If he finds that the driver is competent to drive the vehicle, he will hire the driver. We find it rather strange that insurance companies expect owners to make inquiries with RTOs which are spread all over the country, whether the driving license shown to them is valid or not. Thus, where the owner has satisfied himself that the driver has a license and a driving competently, there would be no breach of section 149(2) subclause A, clause A, subclause 2. The insurance company would not then be absolved of liability. If it ultimately turns out that the license was fake, the insurance company would continue to remain liable unless they prove the owner insured was aware or had noticed that the license was fake and still permitted the person to drive. More importantly, even in such a case, the insurance company will remain liable to the innocent third party, but it may able to recover from the insured. My submission is also to that extent that since on the ground of fake driving license Lordship, the insurance has to pay the amount to the claimant and they can recover. That is up to them. And regarding Lordship, the multiplier, the Honorable Court below has discussed the judgment passed by Honorable Apex Court in Pranay Sethi as well as Sarla Verma. So regarding multiplier, there is nothing remains Lordship. And for a moment, if the review petition they have relied on Lordship, for a moment, if Lordship peruse page 22 of the appeal memo appeal. Lordship, last paragraph, Lordship. Now, in the instant case, the insurance company, within bracket review applicant, was given as many as 6 numbers of dates to adduce DW in the MSC case number so and so. On 12/12/2018, prosecution witness PW was declared closed by the court and the insurance company was given dates of DW. Thereafter, the insurance company took 5 dates consecutively till 16/5/2019 to adduce DW. However, the insurance company failed to adduce their DW and finally on 16/5/19 the evidence from both the sides were declared to be closed and the judgment passed on so and so.
I have admitted all these facts in my submission.
And so, Lordship, my humble prayer for this honorable court will be the appeal may be dismissed. And Lordship, I am submitting one medical documents, Lordship. There is a observation in the judgment at para number. Lordship will got that in page 15 of the appeal memo. Para number 30. The claimant shall open one so and so. Lordship, that fixed part may be waived because the age of the claimant may be considered. Lordship, she is a senior by this time, and Lordship, she is ailing some. Her husband is ailing some medical. She needs some amount for her treatment. Lordship, that part may be modified. Lordship.
Senior citizen and
Lordship, her husband is suffering from disease and she needs some amount for treatment of her husband. Lordship. So, Lordship, that part may be waived. And earlier, the dishonorable court, while granting, they have deposited the 50% of the awarded amount, and the 50% when after withdrawing the 50%, that out of 50%, the sum has been fixed for 25 years. But the bank has stated that fixed deposits cannot be made more than 10 years. Thereafter, the claimant, the respondent herein, Lordship, has filed an IA before this honorable court, and this honorable court has directed to fix the amount for 10 years. So, Lordship, my remitted prayer will, Lordship, that this may be considered and no amount may be made as fixed amount, Lordship. And Lordship may dismiss the appeal along with the interest, whatever Lordship feels.
No, sir, wait, this is a small addendum, Lord. I have no quarrel with him, Lord. I have not filed this appeal on the ground of fake deal. The claimant always gets it. It's only pain recovered at the insurance company. But just a differing point of view on that. In this case, owner and driver shirked their responsibility and did not appear. Maybe belatedly, I had gone before the court to consider my prayer because it's a very honestly, Lordship, insurance company had the advocate had owned up his mistake and prayed that this occurred because of his mistake. That's one point of view about this. A 3 years bench again of like that of Saran Singh, Lordship, by Justice Deepak Mishra, Khanwalkar, and Justice Chandrachudji. It takes for all kinds of fake licenses, driving license defenses. I'll just read out just for the sake of whether my at least one prayer can remain of pain. I'll just read out the particular paragraph. Okay, judgment. That's a para number 13. Para number 13.
yes.
Sort of.
Para number 13, it just says it's about DL. In the present case, the respondent number 1, owner of the offending vehicle, merely raised a vague plea in the written statement that the offending vehicle so and so was being driven by a person having a valid driving license. He did not disclose the name of the driver and his other details. Besides, the respondent number 1 did not enter the witness box or examine any witness in support of this plea. Respondent number 1 is the owner of the vehicle. The respondent number 2, insurance company, in the written statement has plainly refuted that plea, and also asserted that the offending vehicle was not driven by any authorized person and having valid driving license. The respondent number 1, owner of the vehicle, did not produce any evidence except a driving license of one Joginder Singh. without any specific stand taken in the readings or in the evidence that the said same Joginder Singh was in fact authorized to drive the vehicle in question at the relevant time. Only then would owners shift requiring the respondent number 2 insurance company to rebut such evidence and produce other evidence to substantiate its defense. The owner should not always be on insurance company. That's the point I will. Merely producing a valid insurance certificate in respect to the offending truck was not enough for the respondent number 1 to make the insurance company liable to discharge its liability arising from rash and negligent driving by the driver of his vehicle. The insurance company can be fastened with the liability on the basis of a valid insurance policy only after the basic facts are pleaded and established by the owner of the offending vehicle, that his vehicle was not only insured but also at that time was driven by an authorized person having a driving license. Without disclosing the name of the driver in return or producing any evidence to substantiate the fact, the copy of the driving license produced in support was one of a person who was in fact authorized to drive the offending vehicle at the relevant time. The owner of the vehicle cannot be said to have extricated himself from his liability. The insurance company would become liable only after such foundational facts are pleaded and proved by the owner of the offending vehicle. It's Lordship, generally owner of the offending vehicles, they go free scot-free, they do not appear, do not discharge their legal liability, responsibility, and go scot-free. This is one judgment, Lordship, 3 judgments, as good as the Saran Singh's judgment. It speaks of the owners. If insurance company makes 1 year, then his onus is shifts to the owner of the vehicle. That he pleads the foundational facts that so and so was his driver and this was his driving license. Original. These are the foundational facts as far as the owner of the vehicle is concerned. If it is a question of permit, then he has also to mention that it was holding a valid permit. In fact, he has to say this vehicle was being validly driven under a permit or with a valid driving. It's not always that automatically the owner shifts the insurance company. And this judgment is also equally 3 judgment. I raised my case here, Lordship, praying only for pain recovery if it is. Because the owner claimant would not be affected. My learned friend has very strongly defended the owner.
Okay. We will pass the order.
Obliged.
We will not fix it for CAV.
No, judgment. Lordship, it is not CAV.
Not CAV. We will pass the judgment, but by tomorrow it may not be available. It may take 1 or 2 days.
Just one additional prayer while passing the judgment, that statutory deposit refund, Lordship, may.
Okay.
That line may be added. Otherwise, you'll have to file
So
a
what was the actual amount?
It's 54 lakhs.
50?
The actual amount was, Lordship, 83 lakhs something, and since the deceased person was riding his vehicle, that insurance was not made a party. Some amount has been deducted, and the remaining amount is 58 lakhs 10,000.
That is an issue, Lordship.
So I am not on that whatever has been deducted is deducted. I am not on that. It's rightly deducted.
58 lakhs,
that
10,000
was also to be made party. That was not done. 58 lakhs 10,286. 30% has been deducted. Okay. My limited fare will be, Lordship, the fixed amount. Lordship,
What was the fixed amount? 2 lakhs?
No, Lordship. The out of 58, 8 lakhs 10,286 has been fixed. Has been deducted to the claimant, and remaining 50 lakhs has been fixed in 25 different fixed deposits. And out of 25 lakhs has been deposited before this honorable court, and which was withdrawn, and that was fixed before the State Bank. But remaining amount, Lordship, that may not be fixed. That is my limit.
What is the remaining amount?
Remaining amount would be, Lordship, 54,000. Sorry,
50%.
29,000, 29 lakhs, 5,000.
The 50% of the
50% of the awarded amount.
58 lakhs.
50% of the awarded amount already deposited, but the remaining amount fixed may not be, Lordship may not fix them.
Why the entire amount will be, whether the entire amount will be required for the treatment of the husband?
Lordship, the another Lordship, the which the claimant has received 50% from the Sonalbo registry of the Sonalbo court, amounting 29 lakhs. Out of that 20 lakhs, already 25 lakhs has been fixed for 10 years, and that was withdrawn in the year 2022. It will remain till 2032. That amount has already been fixed as per the order of Sonalbo.
We will see.
And further also one more submission, the claimant wants to will some things in memory of her son. That is also one point, but they have stated to me, that is also one.
May I please, my lord,